members, we'll declare the meeting open to the public, and I don't have any apologies. There is draft minutes of the meeting that was held on the 20th of May. And if members are content with their accuracy, then we can sign them accordingly. Thank you. And there's no matters arising. So the Lord Chief Justice is on his way. So we'll just wait on his arrival.
I don't know. I thought it was
Okay, members, can I welcome the Right Honourable Sir Declan Morgan, Lord Chief Justice for Northern Ireland, to the meeting. Also, Chief Executive of the Northern Ireland Judicial Appointments Commission, Ms Mandy Kilpatrick, and Claire McGivern from Lord Chief Justice's office. There's a separate meeting folder that was provided to members for this, and also there's information in pages 2 to 7 of the table pack for further information in respect of the judicial appointment process, and also further correspondence from Judge Marrinan, which we received yesterday. And Judge Marrinan, further correspondence will be treated as further evidence in accordance with the position agreed by the Committee on the 7th of November 2013, which was that all written material provided by Judge Marrinan to the Committee should be treated as formally submitted evidence. So with that said, can I formally welcome the Lord Chief Justice to the meeting. I'm going to initially ask you to make some opening comments, and then we will move on to the substantive issues.
Well, thank you very much, Mr. Chairman. I'm grateful for the welcome and also for the opportunity to meet with you. When we were waiting, we were apparently shown to the armoury, but you'd be glad to know that we left everything behind us, so hopefully this will be a friendly meeting. I'm here today as both Head of the Judiciary and Chairman of the Judicial Appointments Commission, and I've always indicated my willingness to meet with the Committee. I believe that it is a sign of a healthy democracy. It is also important for public confidence that we respect each other's role, and that is the spirit in which I've come here today. My aim, therefore, is to be as helpful as possible to the Committee. And as regards your interest in judicial appointments, the help that I can give you must, however, be within what I consider to be the constitutional and statutory constraints. But I accept that the Committee takes a wider view of its remit than I do, but trust that you will recognise my position and will respect the limitations that I feel able to discuss. But I do, however, want to use this to take the opportunity to place on record my high regard for Judge Marrinan. He has an excellent record of judicial service and commitment, and I have the utmost personal and professional respect for him. Turning to judicial appointments, NIJIC is responsible for the recruitment to just over 650 judicial offices. Since it was established in June 2005, around 60 separate competitions have been run. And this has generated over 1,600 applications, resulting in 327 appointments across the courts and tribunals in Northern Ireland. Many of these appointments have been of lay or medical post holders. Over 100 appointments have been made since the devolution of justice in 2010, and all of these positions have been advertised and recruited in an open competition. Apart from the 3 complaints by Judge Marrinan, there has only been one other complaint to the Judicial Appointments Ombudsman, and that was not upheld, and you may see that it's dealt with in the Ombudsman's report for the period ending, I think, the 31st of March 2010 or maybe 2011. It sets out the nature of that complaint. Dealing then with the selection process. As an initial step in any recruitment process, NIJAC set out the merit criteria in a personal profile, which is accompanied by a job description. The personal profile identifies the qualities that we are looking for in the applicant and the competencies required for the role. The merit criterion is weighted appropriately and assessed by means of selection tools such as an interview, a case study, or in some cases role-play. As well as settling the personal profile, the merit criteria and the assessment tools, the selection panel now at the outset will fix an appointable threshold at both shortlisting and final stage. Only those passing the threshold will go on to the next stage or be deemed appointable. The selection panel for any salaried scheme will usually comprise 4 members, one of whom will be a judge of an equivalent or higher tier, and at least one of whom will be a lay commissioner. When recruiting for the High Court bench, we now shortlist by interviewing all of those who apply. Candidates may be asked questions in relation to a case study and other aspects of the personal profile to assess how they meet the essential elements of that profile. Those who are shortlisted will be called back for a further assessment, which normally includes a further interview and case study. This will examine in depth the knowledge, skills and personal qualities of the role. In assessing individual applicants against the agreed criteria, NIJAC, consistent with guidance from the Labour Relations Agency, requires each panel member to score each candidate individually before collectively reaching agreement on the candidate's final position. This process is known as moderation. In her contribution to this committee on the 8th of March 2012, you will recollect that Mrs. Ruth Laird, then a lay commissioner, described this stage as where the cut and thrust of debate and discussion will go on. At the moderation stage, there is a robust discussion to examine the strengths, weaknesses and development areas of each candidate. The purpose of this process is to achieve consistency and accuracy in assessing each candidate. It is certainly not about adopting an average of all of the individual scores. In fact, this can be the longest part of the selection process and is where the combined experience of the panel comes to the fore. Challenge and balanced judgment is a healthy part of the decision-making process. Invariably, this will involve some adjustment of marks and perhaps a change of view by some of the selection committee on the most meritorious candidate. NIJAC's guidance provides that selection committee members must record where and why they agree to change. Where members cannot unanimously agree on the mark for a particular skill or quality, the majority view will prevail. If the selection committee cannot reach agreement, then under the guidance, the chairman of the selection committee reaches a decision and records the reasons. This has been and still is the practice. If the selection committee feels that further reflection may help, they can adjourn and renew the discussion on another day. Prior to any recommendation, successful applicants will be subject to a series of checks to ensure that they are in good standing for judicial office. That will include a conflict of interest interview. Unsuccessful candidates are offered feedback in a way which is intended to be constructive and perhaps of value in helping them to prepare for future judicial appointments. I hope this gives you a sense of the rigorousness with which we approach our selections. Improvements have undoubtedly been made to our processes, as we have learned from experience. I then want to go on to look at my position as Lord Chief Justice as Chair of NIJAC. I have thought carefully about my own role and responsibilities as Chair of NIJAC, particularly as we are all aware that in Scotland and England and Wales, the judicial appointment bodies are chaired by laypersons. Northern Ireland is, however, different. Our political establishment is different. Our arrangements for judicial appointment are different, and are cast to remove to the fullest practical extent any role for the Northern Ireland ministers. This was a deliberate decision by the main political parties. In the second reading debate on the Northern Ireland Act 2009, Nigel Dodd said, and I quote, "I would have thought that most people were reassured by the fact that there should be no suggestion of political interference in the appointment of High Court judges, given the role they play." This self-denying ordinance by our local parties recognises that we are a society emerging from conflict. This is also clearly reflected in our political structures. The Minister for Justice is selected on a basis which differs from how our other ministers are selected, and those other ministers are selected under d'Hondt, which is in itself a particular feature of our democracy. So long as we have such measures that reflect our emergence from conflict, I think that we should accept the recommendation of the Commonwealth Lawyers Association, a body which is familiar with countries coming out of conflict and which recently carried out a detailed study of constitutional provisions. In May 2013, it recommended model clauses for constitutions which provided, among other things, that the Judicial Appointments Commission should be chaired by the Chief Justice. I hold the position of Chair by virtue of my office as Chief Justice, and I nominate 5 other judicial members, one of whom is a lay magistrate. An independent assessor from OCPA participates in my selection process. The Bar and Law Society nominate a member each, and the lay commissioners are selected by the First Minister and Deputy First Minister. There is no judicial involvement in those selections. Under statute, those involved in the arrangements for nominating and appointing to the Commission are to secure, so far as practicable, that as a whole the membership is reflective of the community. There is a key role here for all of us, but perhaps particularly for the First and Deputy First Ministers. It is both their opportunity and responsibility to ensure that the lay commissioners reflect the community and the public interest and are of the calibre and robustness necessary to deal with the judicial appointments process. All of our lay commissioners are individuals of substance and have an excellent track record of service and contribution to the work of NIJAC. I think that is to the credit of those who appointed them. But I would refer you again to the remarks of Mrs Laird about the important role that lay commissioners play in NIJAC. And by way of example, I would point out that the chair of the selection committee that will appoint the next High Court judge is a layperson, as was the person selected to chair the last County Court judge competition. Finally, I understand the committee may also want to discuss the matter of sentencing. This is one of the most difficult things a judge has to do, and it is never taken lightly. I also fully appreciate the public interest and the need for public confidence. It is a challenge, as the details and complexity of the case lie well below the headlines, but that is what the judge must deal with. Obviously, I cannot discuss individual cases today, but if there are questions of a general nature that you wish to ask, then I am happy to assist as far as I can. There is much to think about, but I hope that what I have said is helpful. I'm sure that you will have some questions for me on judicial appointments and other topics. Thank you very much, Mr. Chairman.
Thank you, Lord Chief Justice. And obviously we'll get to the sentencing aspect once we conclude around the judicial appointments process. And obviously you'll have to advise the committee what you feel you can answer and what you don't want to answer. Obviously, the genesis of this was the evidence provided by Des Marinan and what he provided to this committee, which at the time I said I found to be very profound and very alarming, and that's what spawned this committee to continue looking into it. And indeed, that's why once we conclude this meeting today, before the end of recess, we will agree terms of reference for the inquiry into the judicial appointment process again, and we'll do that piece of work before this mandate is completed. So there are questions that I want to put around the Desmaranan case in particular, and obviously it touches on the broader remit of the judicial appointments process as well. And before I get on to that, obviously we've had an exchange of letters over the past number of months now, which I think has been unfortunate, but nevertheless, obviously you have felt it necessary to try and establish boundaries. But can you explain to me why on the 24th of October, before Desmaranan gave evidence to this committee, your office contacted this committee wanting to come to the Justice Committee, and you would be available on the 14th or 21st of November?
Yes. The reason for that was that I was aware, as a result of notification, possibly from Judge Maranan or others, that he was proposing to come before the committee. And I wanted to do two things. I wanted to alert the committee, first of all, to what I perceived as the legal difficulty over its position, because my position has always been that this should have been referred to the Select Committee of the Ministry of Justice, which has political responsibility for decisions of the Lord Chancellor, and that this committee, for the reasons I've tried to explain, doesn't have responsibility for scrutiny of the decision, but also because I was anxious to ensure that I should give the committee the assistance that I could in relation to the process, because it was clear to me that the letter appeared to misunderstand the process, and I wanted to make sure that the committee in its deliberations had as much information as I felt that I could give, albeit within the parameters of my concerns.
Okay, well, hopefully we can achieve that then today, because certainly the understanding I got from that letter was you were very keen to deal with specifically what Desmaranan had communicated with this committee upon. And then subsequent letters firmed it up, and indeed there was one where you indicated that you wanted to make clear that neither yourself nor the Lord Justice Coughlin could lend themselves to such unconstitutional conduct, which to me was a chilling paragraph to put into that letter, given that we've ensured that this committee is acting within our remit. We've got legal advice, and it is contrary to what your advice is, and therefore we're assured that we are within our remit to be asking around this, and that's why I welcome the engagement. But you'll be used to the phrase "it takes two to tango," and we want to positively engage, but over the last number of months all I have received has been barriers and obstacles put up to that engagement.
I don't accept that at all, Mr. Chairman. I have made it clear in every letter that I've sent to you that I'm perfectly happy and indeed anxious to attend at this committee with a view to discussing judicial appointments policy. Now, you have taken 7.5 months before you have found the space to hear me in relation to that matter, and I'm disappointed by that, but I realise that you are a busy committee with other things to do, and it may well be that it simply wasn't convenient for you to hear what I had to say on judicial appointments policy. I'm disappointed, but sorry that my reference to constitutional behaviour should have caused offence, because I sense that it did, and if it did, I apologise for that, because it wasn't intended to. I suppose as a lawyer I'm inclined to really say things as I see them, without necessarily recognising that there are those who are on the receiving end who may think that in some way or other it is intended to be adversarial or in some sense disrespectful to the committee. As I said in my opening remarks, I think it's important that there should be respect among all of those who hold public office in this jurisdiction. And I'm coming here today and trying to do the best that I can in relation to, within the boundaries that I feel are imposed upon me, to ensure that I show my respect to this committee.
Finally, and then I'll get into more substantive issues, we did get correspondence from Desmaranan yesterday, and if someone's able to avail it to yourself, because it does disturb me, and hopefully you'll be able to clarify for the committee if this is true, but he indicates to the committee that you contacted him after his appearance and threatened him with disciplinary action.
I contacted him after his appearance because of the remarks he made about whether or not, I didn't threaten him with disciplinary action, but I did contact him after his appearance before the committee, where he suggested that he would not get a fair hearing from senior judges in this jurisdiction. And I told him that I considered that to be, I can't remember the precise term used, but disrespectful to the senior judges in this jurisdiction, who, so far as I could see, have always behaved independently and would do so if required to. I mean, there is, and I'm not sure if you're aware of it, there is a precedent for decisions of a Lord Chief Justice and indeed the Lord Chancellor having to be dealt with by a puisne judge. And the puisne judge found that there had been unlawfulness. I mean, the notion that a senior judge in this jurisdiction would have the least difficulty in dealing independently with a decision that I happen to make or that any other judge happened to make is frankly risible. If on the rare occasions when I do sit at first instance, am as much appealable to the Court of Appeal. I have been on occasions reversed by the Court of Appeal. I've been reversed by the Supreme Court. I have no difficulty whatsoever about making decisions and being accountable for them. But I do take issue with the suggestion that the judges of this jurisdiction are so mealy-mouthed or lacking in independence that they would have difficulty in dealing with issues on their merits. And I'm surprised at that comment from Judge Marlin, because he is one of those judges that I would have thought would have had the courage and independence to take exactly that course if he was faced with it.
Well, we can get
But I didn't threaten him with disciplinary action. I told him that in other circumstances I would have had to consider disciplinary action in relation to any judge who had made such comments about the judiciary. But in light of the fact that he had been ill, and I recognised that this issue was very close to him, that I didn't think it would be appropriate for me to take the matter any further.
But given the gravity of what he had indicated to this committee, and obviously the personal trauma that it caused to him, which was evidence to everybody, to then communicate with him after his evidence, and now he indicates, and it's in the second paragraph, that you did say you were minded to subject him to disciplinary action, but because of his illness in the past, you weren't going to pursue that particular option. That, to me, would have had a chilling effect on Des Marinin as well. And it also, when we talk about constitutional boundaries, I believe interferes with this committee, given that we had him as a witness. We were indicating that we may well need to come back to this issue with him. And in the interim, you have corresponded with him threatening disciplinary action.
I didn't threaten him with disciplinary action, as I've indicated to you, but I have a responsibility to ensure that the rule of law in this jurisdiction is respected. And where people suggest that the judges of this jurisdiction are neither courageous enough nor independent enough to make the decisions that are required of them, it is my responsibility to ensure that I make that clear both to those who do it and to the public generally.
He indicated in his correspondence to us that he firmly rejected your allegations and was seeking clarification, which he hasn't got. And let me quote what he said to this committee. "I felt intimidated by his letter and felt it was wrong to write in such terms to a witness who might yet be required to give further evidence to the committee. My health suffered again. As a direct result of this letter, I required further consultant treatment."
And what are you asking me to comment on?
Given that information, in hindsight, do you not believe that your letter was inappropriate?
No, because I have a responsibility to ensure that those who denigrate the independence and courage of judges in this jurisdiction should have it pointed out to them that they are in error, and particularly where a judge casts doubt on the independence, courage and integrity of colleagues, then it seems to me that I have no option The fact that I indicated to the judge that I would not take action because of his position was designed to recognise that I understood that he was a person who might be adversely affected if I were to go down that road. And I consider that that was entirely appropriate.
So
I'm obviously, he has never indicated to me that it had any effect on his health. I have regularly, and I don't really want to go into the detail of this, but regularly had contact with his presider because I have been concerned about his welfare to ensure that the steps that have been taken in relation to his working conditions have not adversely affected his health, and so far as possible that they have been beneficial to him. And I had indeed lunch with him no more than 4 to 6 weeks ago on an entirely amicable basis where he made no reference to any of this to me.
Yeah, well, certainly we've now added it as the evidence that he gave us to this committee.
And you've got my evidence as well, and no doubt we will be able to take all of it into account.
Yeah, and we certainly will. But when you indicate the slur that Mr. Marrinan caused when he did give evidence to this committee, maybe he was wrong. And I'll quote from him. He said, "Many in the legal profession know that what happened was very wrong and have contacted me to express their sympathy and distaste for the Commission's behaviour. Several senior judges, including High Court judges, are included in that group." So it would appear that Des Marrinan isn't alone.
Well, no High Court judge has expressed any concern to me about the way in which the competition was handled. I mean, I am concerned that Judge Marrinan was so affected by his failure to succeed in this competition, obviously. He's a person that I've known for many, many years. We have worked together. We have had perfectly amicable social relations. He was supportive of me on my appointment to the High Court bench. He was supportive of me in my appointment to Chief Justice. The last thing in the world that I would have wanted in relation to Judge Marrinan is that he should have felt unwell as a result of his failure to succeed in this competition.
Okay, well, look, if you're content, I would like to try and go through some of the procedural issues, the way NIJAC operates, and some of that pertains to this particular competition. And the evidence that we received, and indeed it was one of the complaints that were upheld, the Ombudsman did uphold a complaint on the perception of bias and that there was closed minds.
I think the term he might have used was perception of unfairness, and I'm stand to be corrected in that. Again, I think I need to be quite careful about the extent to which I can go into this. All I would say is that there were, as you know, I think, about 24, 26 complaints that were made. One of those was a complaint about whether or not the selection committee should have recused itself. That complaint was rejected by the Ombudsman, as you know. The Chief Executive, who wrote to Judge Marrinan after the first interview, indicated that the committee had accepted his representation that there should not be a requirement for written work. He did not respond to the suggestion that the committee should recuse itself. It was on that basis, as I understand it, that that finding was made, and I recognise that the Chief Executive, who was then in post, should have advised Judge Marrinan that the committee had decided not to recuse itself.
On the issue of the moderation process,
Yeah.
is it normal in the moderation process not to complete the process of moderation? That was one of the complaints that the Ombudsman upheld in this particular competition.
The moderation process should always complain. I mean, you'll see, again, without going into it, I mean, you have access to the findings of the complaint committee that I chaired, where we touched on this and reached a conclusion. The moderation process, of course, should always be completed. It doesn't have to be completed, because I think there was some issue about this in your discussions. It doesn't have to be completed on the same day, in the sense that we take the view that sometimes the opportunity to go back and re-examine the papers, with a fresh mind on a subsequent day is an appropriate way in which to conduct matters. And we're sufficiently confident in the ability of our commissioners to resist any sense of outside pressure or anything of that kind to feel that we can do that. What I think I've sought to make sure that this committee is aware of is that it is the case on occasions that people disagree, and it is the case that sometimes the disagreement can't be resolved. So that if you get to a stage, and I'll take as an example, that 3 people say that a candidate should get no more than 15, and 1 person says that a candidate should get no less than 17 in relation to a particular skill, there has to be a mechanism of working out what the answer is. And the answer and approach of NIJAC, both before the time that I became chairman in July 2009 and subsequently, is that the majority view should prevail. In other words, that in those circumstances, the moderation mark should be 15. And that is to reflect the fact that it accords with the consistent view of the majority of the members. Any other result, it seems to me, would mean that the majority view of the consistent view of the majority of the members would not be respected. So that is the policy, and that is the way in which, if at the end of the day there is no agreement on moderation, that is the way in which the moderated score is actually determined.
And this,
that, it seemed to me, was one of the issues which I was concerned about when I saw the letter which provoked my correspondence of the 24th of October.
and leaving aside the moderation process in this particular case, although that is important because it was only when the score seemed to be heading in a certain direction, a decision was taken, let's stop.
Well, indeed. I think one needs to be careful about this. The discussion on moderation had gone on from something like all afternoon, well into the early evening. The position in relation to the scores, as I understand it, you have in your papers. This is not a half-hour discussion. This is a long and detailed discussion in which you will see what the views of the members were about what the moderated score for the skill that was not filled in was. You will know if they'd had to moderate on the night as a result of what I've explained to you, what the moderated score would have been. And you, presumably even without your calculators, will be able to work out what the outcome in those circumstances would have been.
Well, in terms of the first stage of this, until the second interview was brought in, I think there was correspondence from Lord Justice Coughlin, who presided over this particular panel, indicating that they weren't prepared to appoint on the basis of 1 mark. Would that be normal in a competition, that if there's only a difference of 1 mark between candidates, that they wouldn't appoint someone?
Our view is that when you get to the final outcome, these are jobs in which people are likely to be in place for 15 to 20 years, and where it's quite difficult to remove people from office. So one has to be, you can't really make a mistake. You have to try and ensure that you've got it right. And our view is that where you've got candidates who are very close together like that, that you should reflect on whether or not you're satisfied that the competition has been testing enough to ensure that the distinction that you have satisfies you that you've got the right candidate. Now, in most cases, that will lead to the candidate who has most marks, as long as he satisfies or she satisfies that, getting the post. But people are urged to reflect on the basis that this shouldn't become a pure arithmetic exercise. The problem is that if you go behind the arithmetic, you have to be able to justify and articulate exactly why it is you didn't follow the arithmetic. And that places a very heavy burden on those who are conducting the selection process if, for some reason, they go outside the arithmetic. It didn't happen in this case, obviously, because there was no question of anybody being appointed on that sort of basis.
There was only one mark, though, of a difference between them, and both of them...
There was no difference between them.
In the first stage, was there not a difference?
There was no
of one
difference.
mark? There were...
That's the point. Once you understand moderation, you can see there was no difference.
In terms, then, of there being no difference, okay, recommendation is made, Lord Chancellor knocks it back.
Well, no, sorry. After the first, when there was no difference, there was then a second stage, and on the second stage, that was used to continue the moderation process, and there was a clear winner after the second stage. Mm-hmm. So I'm not sure where we are now in the process. So that's the selection committee has done its work.
Well, the point being from the previous evidence was this was the process. The moderation does its work, and there's a rounding up and a rounding down.
No, there is no rounding. That again is both a misunderstanding and a misdescription. There was a robust exchange of analysis of the quality of the evidence, what it demonstrated, what it should lead to, why people had the different views that they had about the candidates. That's what moderation is about. It's not about rounding one way or the other.
And the comment that was made in the evidence that I put to Des Martin at the time was it was Professor Morrison, I think it was, seemed to be the main centre of attention, but yet Justice Wellerup had consistently marked Des Martin down. He was out of kilter with the other three, but yet the focus was on Professor Morrison's particular score.
The point is that in moderation, as I've tried to explain, in moderation there is a robust discussion about what the evidence demonstrates, qualities that it's demonstrated, what is the appropriate arithmetic mark to place on that. Now, as I've tried to explain, that invariably leads to a difference of evaluation of the quality of the evidence and influences, therefore, the appropriateness of the scores. The scores that come out in moderation are almost never the same as the score of an individual member. Almost never. But I'm sure all of you who've been in this type of process know this or know something of it. I mean, obviously the process is different depending upon how rigorous they are. But certainly from my own point of view, the notion that individual scores should simply be averaged out, I would find entirely unsatisfactory, because it seems to me not to be a rigorous process at all. It doesn't involve people having to defend and explain why it is they've come to the view that they have in relation to a particular quality. It is that requiring somebody to think through and be able to explain why it is that they've come to the view that helps to ensure that the process has the robustness that we think it has.
And a number of us have, and indeed I have. I sit on 2 boards of governors of schools, I appoint teachers,
Yep.
and what is always made clear to me in that process is you always complete the moderation process. In this case, in the first stage, your panel didn't. It totted up 4 and there was a 5th, and it didn't complete it.
Mr. Chairman, I don't know what the purpose of the repeat of this question is. I think I have answered it, and I think I have pointed out to you that it's not just an answer I'm giving today, it's an answer I gave when I chaired the Complaints Committee. I've never taken issue with that matter. All I'm seeking to do in here is to make sure that there's an understanding of the processes that would actually apply, so that you're in a position to understand what would have happened if the moderation had been completed on the evening.
Okay. So we move to the second stage interview. There's now a clear difference between the 2 candidates, of which there are only 2 candidates.
Yeah.
The recommendations are made to the Lord Chancellor, and it's knocked back.
And then there's a complaint. Yeah.
And whilst the complaint is being made, there's another recommendation.
Yeah.
which the Ombudsman upheld against the Commission, that it had dismissed the work of the Ombudsman's office, carried on regardless.
I don't think the Ombudsman quite put it like that.
Well,
but let me try to explain what we saw, or the majority saw, as the appropriate way forward. Our view was that at that stage we had accepted the recommendation in relation to who was the winner on the selection process. We then debated whether it was for us to wait for the Ombudsman's report and then decide what consequence it should have in relation to the outcome, or whether we should send our work to the Lord Chancellor and indicate to him that there was an outstanding complaint and that he, as a person having political responsibility, should determine to what extent that recommendation was affected by the Ombudsman's report. We concluded that we should do the second of those. In other words, we sent it to the Lord Chancellor, pointing out that there was a complaint, so that the Lord Chancellor could then decide how he should respond to the complaint. The Ombudsman took a different view. I entirely accept that.
But we get to the point then in this particular competition where the Lord Chancellor has knocked it back, and of course ultimately the Commission can press ahead because the Chancellor can only ask you to reconsider. But for whatever reason the Commission have decided not to do so, and then you have a recommencing of the competition, and we're now already, I think, 2 years maybe at this point into the process.
Yep.
And rather than me say it, the evidence Des Marinan gave was the rational, fair and reasonable next step, I argue, was to recommend me as the sole remaining and clearly appointable candidate. But following its now established pattern of unfairness, the Commission refused to endorse me and chose instead to abandon the competition in a pre-entry fashion without consultation or explanation of any kind.
All right. A couple of things about that. First of all, as you know, our statutory responsibility is to promote diversity and to ensure that we select the best available candidates. As you say, time had passed by the stage that this matter came up to us. There is the statutory onus on us in relation to responding is contained in the Justice Act in section 5(6). For the reasons that we've explained, we recognised that that enabled us, if we thought it appropriate, to reopen the competition if we wished to do so. We felt that with the passage of time that there were likely to be other candidates out there who would not have been in a position to apply 2 years beforehand. We recognised that we were down to a pool of 3, all of whom were judicial office holders, only 2 of whom had actually got through the initial shortlisting process. And we decided that the public interest in diversity and in the selection of the best available candidates outweighed the private interests of the people who were involved. That's the judgment that we made. And in the next High Court competition that followed, there were 13 applicants, 11 of whom had never applied for High Court appointment before. They included a range of women. They included solicitors. We'd never had a solicitor candidate before, and practising members of the bar. And in my view, that vindicated the view that we took, that that was in the public interest the right way forward.
But at every stage, Des Marinan had been told this is a live competition.
It was a live competition. The only thing that we did was that we reopened the possibility of other applicants coming in.
In terms of the diversity aspect, was there not already a number of other posts that were available for appointment?
There were other posts available for appointment, but at the time that we made the decision, we had intended to advertise all of them together. And we saw this as an opportunity to ensure that we would get a good range of candidates coming in.
I'm trying to put myself in the shoes of the applicant, which in this case was Des Marinan.
I understand that, and that's why I said that we had to balance the need to ensure that we were fair to him with the need to ensure that we respected the obligation that was placed on us to act in the public interest. And the question was whether or not to proceed in a competition in which there were only two, in a sense, or maybe even one live candidate, which had started off after the exclusion of the other candidate, which at any time only had 3 existing judicial office holders. So it was going to be judges appointing judges, if you like, was the charge that would be laid against us. Or it was appropriate to ensure that others that we thought may be interested, and indeed experience showed were interested, should be given the opportunity to come into the competition and compete with those who were left. And if those who were left were better, they would have been appointed, and if they weren't, they wouldn't. And what we ended up with as a result of that was the best candidates on merit who were available at the time.
I'm still struggling to see how the public interest, and let's define public interest. There's a starting
The public
point.
interest is in diversity and in making sure that the best candidate on merit who is available is appointed. And available doesn't mean just who has applied.
Well,
it means available.
There still isn't a female High Court judge for diversity, if that was the argument. But
As you know, Mr. Chairman, when I came to this committee either last year or the year before, I was asked the same question, and I said at that stage that there are 6 posts potentially going to arise in the High Court in the period up to the summer of 2017, and I expressly invited this committee to bring me back in 2017 if there wasn't a woman judge among them, at least one.
if we're all here after those elections, we'll do that.
That is an invitation I think might be taken up in certain circumstances if this turns out not to be the case.
The time lapse, though, wasn't as a result of Des Marinan, and that's where it seems punitive on him, in that he was the only other acceptable candidate. He was well above the threshold, is what was
There
deemed
wasn't
required.
a threshold fixed. That's another of the misunderstandings. The fixing of a threshold for appointability was something that was introduced shortly after I was appointed, where we fixed a threshold for shortlisting and a threshold for appointability. What we did before that was that we fixed minima, which had to be satisfied in relation to each and every category, and we still do that. But of course, the appointability hurdle is significantly higher than the sum of the minima.
Because I think it was 79% was mentioned.
There was a minimum. That you had to get at least, if you didn't get 79%, you'd have failed one or other of the 5 categories. But I mean, we wouldn't use that as an appointability criterion. We'd be looking for something in excess of that. I think the last county court competition, the bar was set at 85%. That's the sort of approach that would now be taken.
I think Lord Justice Coughlin described initially both candidates as excellent.
They are both excellent. All of my county court judges I rate as excellent. I mean, one of the things that we won't touch on today, but I will say in passing because it is a tribute to them. When I came to this committee last year, Mr. McCartney asked me a number of questions about delay in the criminal justice system. And one of the concerns was about the outstanding number of criminal trials in Belfast in particular, of which there were 322, I think, in October 2012, and we brought it down to 220 in April 2013. And I'm glad to tell the committee that thanks to the sterling work of my county court judges, that figure is now down to 91. And that represents a real commitment and real effort by excellent judges dealing with what was a problem.
The time lapse that had passed the 2 years, again, in terms of how some may regard it as being punitive on the other successful applicant in terms of the criteria, indeed the only sole applicant that should have been appointed had you not recommenced the competition, wasn't of his making, in that for at least a year there wasn't a recommendation made. And indeed, I think the Ombudsman upheld a complaint because your office got involved with DETI to do with disqualification issues with the Presbyterian Mutual Society.
I entirely accept that. The complaint was because we didn't know what the timescale was likely to be. As chairman of NIJIC, I considered that it was appropriate for us to make an inquiry from DETI to let us know how long it would be. I asked my PPS in the Judicial Office to make that inquiry. the Ombudsman's view was that I should have asked my Chief Executive in NIJAC to make the inquiry. There was no criticism of the fact that I made the inquiry. It was considered an entirely appropriate thing to do. Simply the letter or call was made by the wrong person. I'm not going to take issue with the Ombudsman in that, although, I mean, for reasons that I would go into with him and possibly have a longer discussion with him about, I think that one needs to recognise that my office is appointed the chair of NIJAC. It's not an accident that I'm the chair of NIJAC, and there is therefore a crossover, and the question is where the boundary to the crossover is between my role and that as chair of NIJAC.
Finally, and then I'll bring in some other members. I know there's some other points, but in terms of that recommencing, and I think this was a point Mr McGuinness made, and you've referred to the powers under 5(6), where it states after doing so either reaffirm its selection or select a different person to be appointed or recommended for appointment to the office. And when I put that to Des Marinan, and I put it to him that if statute says the Commission must move on to select someone else, did the Commission break the law in failing to appoint you? His response was, yes, in my view it did. It was an illegal act in my view.
Yeah. I mean, I think he's wrong about that. I don't mean any disrespect to him when I say that I think he's wrong about that. And I think, with a bit of luck, I'll be able to demonstrate why I think he's wrong. I mean, take the example of only one candidate who was considered appointable who is disqualified, and you've got 3 unappointable candidates. How do you, in those circumstances, if you're faced with that, how do you select a different person? The only way, let me put the point to you again. If you have a competition where you have 1 appointable person and 3 unappointable people, and the 1 appointable person is then excluded for one reason or another, and therefore is no longer in the competition, and you're faced with the 5(6) requirement to recommend someone else for appointment, how on earth can you do it unless you reopen the competition? I mean, that's why the judge in that particular issue has just got it wrong.
And was Des Marinan then one of 3 other appointable?
No, I'm trying to make the point that 5(6) doesn't have the effect that he thought it had. 5(6) is actually the basis for reopening the competition. That's the point I'm trying to make.
Well, he did elaborate in that comment, and he did say even if the Commission acted technically within its power, it was so irrational and so unfair. Had I felt confident about going for judicial review and not fearful that I might end up bankrupt by doing so, I would have been very hopeful, given a fair wind, that a judge would have found the decision to be irrational and they have the appearance of bias against me.
I mean, if Desmond had felt and been advised that he had a good case, I mean, he was entitled to pursue it. If he had difficulties about my conduct in any of this, and I don't think he had, because I think in his evidence he expressly disavowed that, he, as he explained to you, knows that there's a complaints procedure where any complaint about me would be investigated by a Supreme Court judge. During the 4.5 years that we've been looking at this, there's been no complaint of any sort in relation to me or any judge associated with this process. And that is because there's no basis for it.
Although, if you were put in Des Marinan's position, the prospect of, I think he touched on £250,000 may well have been the cost of litigation had he been unsuccessful.
Well, there are ways and means of doing these things. I mean, I recognise that if somebody had wanted to do that, there are mechanisms which he could have considered, such as pro bono representation, a protective costs order, which would ensure that costs were kept to, if there was a real public interest in the issue that he wished to pursue, there is a mechanism which ensures that costs are kept to an affordable limit. It's used regularly in relation to challenges to environmental decisions. There's a great deal of authority in relation to it. He could have, if he had complaints to make about the conduct of a judge, he could have made a complaint about the conduct of a judge, which would have then been dealt with by a judge of the Supreme Court at no cost whatsoever to him. I mean, there were mechanisms available here if one wished to take this further, and they weren't. And the reason they weren't, in my view anyway, is that I can't see that they would have stood any reasonable prospect of success. Again, I don't want to appear to be in the least critical of Desmond. He's a very good judge. He's a hard-working judge. I have, as I said, the utmost respect for him. But there are some of these things that he's got wrong, and he, in his own evidence, made the point that some may think that he's acted obsessively in relation to that. I'm not saying that he's acted obsessively, but I do think that one needs to be very careful not to be a judge in your own cause.
And I think that the point that some members of the judiciary may say, as the Lord Chief Justice, as chairman of NIJAC, chairman of the Complaints Committee that looked into this particular competition, is that not exactly the case for yourself?
Well, all the decisions that I've taken on advice, or they're decisions which I was required to take. But where I've needed advice, I've taken it, for instance, in relation to reopening the competition, in relation to the view that I took about what I can do in relation to this committee. I just didn't dream it up. I took advice, and I've tried. As you know, in relation to the appearance before this committee, I took the advice and I then set out what the terms of the advice were in the correspondence I had with you. I'm trying to be as open and transparent as possible. I perfectly understand that this committee didn't feel able to share its advice with me, and I know the rules in relation to bodies such as this sharing advice are different. If you show it to me, you probably have to start showing it to everybody every time you got advice. And I'm not getting anxious, at least about that. But I suppose it's that bit easier for me than that. I generally only come to see you about once a year, so if I have advice about things, I can probably manage to tell you what it is.
Okay, well, I'll park my line of questioning for now and bring in other members. Mr. McCartney.
Thank you very much, Chair, and thank you very much for your presentation. In many ways, I can say I think I'm actually surprised that you've answered some of the questions today, because
I'm trying to do what I can.
And we appreciate that, because I thought that your advice was that you shouldn't enter into
I shouldn't enter into scrutiny, and that's the point is that I can get into policy and I can get into process, but my advice is that I should not enter into scrutiny, and I'm trying. Scrutiny is not a white line. There's a grey area around there, and I'm trying to make sure that I don't stray from grey into black. That's really what I'm trying to do.
Again, and we're advised just in terms of the questions that we can or can't ask, and obviously that's a matter for yourself, but in his evidence to the committee, Des Martin said that there is more than one letter to the Lord Chief Justice, the chairman of the Complaints Committee, that they were not prepared to award the competition on the basis of one mark. Is that a factual?
Sorry, just give me that again.
The Lord Justice Coughlin said in more than one letter to the Lord Chief Justice, the chairman of the Complaints Committee, that they were not prepared to award the competition on the basis of one mark. Is that a factual?
I think that, I mean, you have, whatever letters there were, you have, so you'll be able to see what's there. And there was a remark of that kind which is definitely contained within the correspondence. But I mean, I think I have to make the point that if you go through the process, what I'm trying to do is again, and I'm straying into grey here, if you go through the process and you apply the moderation in the way that we always have and in the way that I've explained to you, the result is not a difference of one mark, the result is equality.
But it strikes me, then why would Lord Justice Coughlin say that?
Because I think that was the point being made by Judge Marilyn, that he was 1 point ahead. But he wasn't.
No, but I mean, my reading of this is that Lord Justice Coughlin is actually accepting the fact that he would not be prepared, and he says they, as in the selection committee, we're not prepared to award the competition on the basis of one
And I
mark.
can-
So
I can-
he
I
seems
can-
to be
I
accepting.
can well understand why they might not have, for the reasons I gave earlier, which are that where you've got a competition and you've got two candidates who are very close together, the first thought that should cross your mind is, has this competition been rigorous enough in separating out the qualities of these candidates? And one of the things that you should, in my view anyway, when you're looking at an appointment that is as important as this, you should consider whether you should have a further round to test the candidates further. I mean, that's is a discretionary judgment, which it seems to me should be open to any selection committee faced with this type of situation.
Yeah, but in a competition of this type,
Yeah.
we're given the calibre
Yeah.
of the people involved. One mark could be a considerable margin of merit.
And that's where the area of discretionary judgment would come in. It would be a matter of discretionary judgment, because you would look, among other things, at the balance of the marks, because there are 5 different areas to be looked at. You would stand back and ask yourself the question: well, am I clear that I've now got, if you like, a clear winner, or a person who is the best candidate on merit? All I'm saying is that the mark should not prevent the question being asked in a rigorous and robust process: do we need to do anything further to make sure we've got the right person?
But say, after all that rigour, if someone still...
In the end, you have to make a decision. I mean, let's be absolutely frank about it. You can come to a situation where the arithmetic marks are the same, and you have to make a decision. And you see that, well, if you pardon me, I'm sorry for interrupting.
No, go ahead.
But you see that, for instance, that under the Equality Act in England and Wales, which we don't have here, the provisions are that where the candidates are equal, that there should be, I use the term, and I don't mean it in the way it might sound, there should be a bias towards underrepresented groups. So you can have situations where the marks are equal, and somebody has to make a decision about, in those circumstances, do you go for something further, or if you think that there's no point because these candidates really are very evenly matched, why it is, and you need to be able to document and articulate it, why it is you say that one candidate is on merit the better candidate than the other. You have to be able to do that.
But the sort of point I'm making is that someone wins the competition by a point, by 1 mark.
If someone wins the competition because they are considered the best candidate in merit, and that can be by 1 mark, yeah.
Yeah, and then the moderation isn't completed, and then it turns around that in the next run of it, you get a different result.
No, but again, I mean, I'm probably straying now, and I'll say this for the last time, into the black, because I really can't go any further than this. If you examine the moderation and take into account what I've told you as to NIJAC's processes and procedures in relation to it, you will see that the notion that a candidate won by 1 mark is not correct. So
And I have no reason to doubt what you're saying, but Lord Justice Coughlin seems to be of the same opinion, that they were prepared to, and he seems to be relating to this case.
Well,
so the issue of 1 mark isn't something which, is abstract or can happen in a competition. It seems to be said here very clearly that it happened in this instance.
No, it's not. And all I can say to you is that it's not.
So that...
But I mean, you need to see that. I mean, I'm not. That's where I am in the black. You'll need to go back and look at the context of the letter, but I'm telling you that it's not.
And that's a fair point. In terms of the NIJAC gave us a number of documents. If I could just, they're not
I hope
tabulated in any way, so...
Hope you find them
Yeah.
some assistance.
They were. In relation to this one, is this the procedures in 2008?
Sorry,
I think it's the first.
I think I sent those through, and it would be the procedures of 2008 which applied in 2009.
In 2009, and then you sent us on a
current
second set,
procedures.
which is 2012.
Yes.
Is that the set of documents which would guide any further selection process?
At the moment, those are the up-to-date
Yeah.
documents, yeah.
Because I think in both of them, it's more explicit in obviously the recent. But in my reading of this, it says that on the day, and this is point number 7 in 2012,
Yep.
and it's point 713 in brackets. And that's ensuring that all paperwork is fully and appropriately completed and signed, including the moderate assessment form and the assessment matrix merit list.
Yeah, well-
On the day.
At the end of on the day of the assessment event, the chairperson is responsible for, but that doesn't mean that the completion of the paperwork mightn't be, we decided to adjourn in relation to X and meet again on such and such a day.
Yeah, but I mean, it would still allow for that, although it doesn't say anywhere in this that there's provision for adjournment. It's
I
not.
sincerely hope you can, because I've done it.
Well,
one of the
I'm only-
conversations where I felt that there was a need for it.
Yeah, but I can only take this as it's
No,
presented. I mean,
And
it's
that's why I
understandable
tried-
on the day that there will be a degree of flexibility. But if we take it that on the day means the day of completion,
Yeah.
then the matrix and the moderation should take place.
And that, as I've said to the chair, was something that as chair of the Complaints Committee, you'll see I dealt with within the Complaints Committee, and I'm sure you've read my findings, you know the findings we made in relation to it, and I have never taken any issue with that.
Yeah. So there's an acceptance that the guidelines weren't followed.
I've never taken any issue with the fact that the Ombudsman's conclusion, and that was a conclusion that we accepted, that all of us accepted. I think the thing that I've been worried about is, and one of the reasons that I wanted to speak to the committee was that I wasn't entirely sure that people had worked out what the consequence of that was, in terms of what the outcome would have been if the figure had been filled in.
Yeah, but I mean, in terms of procedure, I mean,
I'm not. As I say, I'm not taking issue.
No, I know you're not, and I appreciate that, but I'm just, in terms of public perception,
Yeah.
that if there's, particularly in a high office, you know, and particularly a judicial office, that if there's a set of guidelines which are required to be followed, they're not followed, and they're found by, obviously, the Lord Chief Justice that they're not followed,
Yeah.
and then upheld by the Judicial Ombudsman, then I think a lot of people would say that the competition would be declared null and void.
Yeah, but as I've tried to indicate, the Ombudsman, who looked at this very carefully, didn't accept that. And part of the reason that he didn't accept it was that he understood that that the error here was the failure to fill in a figure, and if the figure had been filled in, then the competition would have proceeded in exactly the way that it did.
Yeah, but can you understand why?
I know, of course I do.
Yeah.
And I'm not trying to, in any sense, to take issue with you. That's something that should not have happened. Accept that. But I don't accept that once you're informed of all of the facts, I don't accept that in any way it affected the outcome of the competition at all. And that's the point that people need to understand, that it didn't affect the outcome of the competition at all, because once you see what the position was, the competition inevitably was going to take the direction that it did.
But again, I understand that it's difficult to ask questions without the circumstance in which are presented, but given that there was our complaints made, would it not be in the best public interest, perhaps to say, rather than find ourselves in a position that, you know, again, it's a judicial office, that we're in breach of our own guidelines, yet we proceed by just simply explaining it away?
Sorry.
By explaining it away, by saying, well, if we had a followed
I'm
our own
not trying to
procedure.
explain it away.
But it was explained away in a sense, because what you're saying is that the guidelines were broken, but because if they had been filled in properly, then it wouldn't have affected the competition.
But what I'm
I think in
saying-
essence, the core point I'm making is that the guidelines weren't adhered to, and that's the issue.
Of course, the guidelines weren't adhered to the letter. The point that I'm trying to make is that where there has been, and we deal with this all of the time, where there has been any form of breach in procedure, the question that you have to ask is whether or not the breach of procedure adversely affected the process. Now, you can have a breach of procedure that doesn't adversely affect the process. That's what this was. And that's why that's what I've tried to explain. And I don't think I can take it any
No,
further.
it's fine. No, I appreciate that. It's just in terms of when Judge Martin was in front of us. I mean, I don't think he was quiet. Now, I don't know the mind, so I can only go by what he said, because he was very glowing in his terms about all the judges and all the people that he worked with. But I think the point he made was he had no faith, because in the sense that perhaps asking other people to sit in judgment of a colleague is a difficult thing to do.
But I don't accept that.
Yeah.
I mean, as a puisne judge, I would not have had the least difficulty in dealing with a case in which somebody was suggesting that the Lord Chief Justice had behaved unlawfully. I would have considered it my duty to ensure that I dealt with the case independently and courageously, and if a finding was necessary to decide that the Chief Justice had behaved improperly, the finding would have been made. I would be appalled to think that there are any of my colleagues who think differently. If they do, they should never have been appointed. Judges have to be courageous and they have to be independent.
Okay, thank you.
Thank you.
Mr Humphrey?
Thanks, Chair. Lord Chief Justice, thank you very much for your presentation and your answers so far. Can I ask you, as Lord Chief Justice for Northern Ireland, do you think this whole debacle is unedifying and potentially damaging to the judicial system and to NIJAC?
Yes, I do. I mean, I don't, again, resile from any of that. There were 4 complaints that were upheld by the Ombudsman. They're the only 4 complaints that have ever been upheld against NIJAC. I'm the chair of NIJAC. I recognise that there's an issue of public confidence that I have to address, which is why I, if I may repeat again, was anxious to come here so that I could, if you like, put more flesh on the bones as to all of these issues insofar as I felt able to do it. But I agree there is a responsibility on NIJAC and a responsibility on me as the Chair and the Chief Justice to ensure that public confidence in the judicial appointment process is secured.
So, following on from that then, and thank you for your candid answer, do you think that perhaps a review of the process and procedure needs to happen to give people that confidence?
Well, I think that one of the things that should engender confidence in the public is that the whole point about having a judicial appointment ombudsman is that the ombudsman, as you see, has made a series of recommendations. Well, we have in broad terms implemented those recommendations. And the ombudsman's task is, as the person who is most intimately involved with the process, not just here, but also in England and Wales, to bring best practice to our attention. And he has been doing that, and we have been implementing it. There are things that we've done which are designed to ensure that we will improve yet further the process. And one of the things, and for instance, we're doing at the moment is that we're looking at devising, and we're working in conjunction with our colleagues in England and Wales on this, a qualities and abilities approach towards the selection of judges, which will broadly ensure that the qualities and abilities are worked right the way through from the top to the bottom, but that the weighting of those qualities and the hurdle that you may identify in relation to them would be different depending upon the sort of task. But it's only an example of the fact that we recognise that if you're not continuously improving, you're not doing your job properly.
I appreciate what you're saying in terms of the Ombudsman, but can I ask you directly, as Lord Chief Justice, as head of the judiciary in Northern Ireland, do you think, given your experience, years of experience and the position that you now hold, that a review should happen as a law officer?
It depends what you mean by a review. I think it is good governance for people to carry out searching reviews of all public authorities to identify whether they're doing the job as well as they should. And I welcome a review because I see it as a mechanism of ensuring that, that these tasks are carried out to the highest standard, because that is what we are able to do. So I'm welcome that. I think review is part of a good governance approach, and we are certainly very anxious to assist in everything we can do in relation to that.
Well, given the experiences and the difficulties that have arisen over this particular issue,
Yeah.
do you believe that there should be a separation of the role of Lord Chief Justice for Northern Ireland and Chair of NIJAC?
No, I don't, for the reasons that I've given you, at least not at this stage. I mean, if we get to Mr. Dodds, when he made the remark in the debate on the 2009 Act, which, if you remember, Paul Goggins, the late Paul Goggins, introduced, Paul Goggins, in a passage that I haven't referred to, explained why it was felt that the judicial appointments process should not have direct political involvement from ministers. Now, what happens in relation to the selection of lay members is that lay members are, of course, appointed by the First and Deputy First Minister, and they're appointed in a rather different way from the way in which my judges are appointed. We appoint strictly on merit, depending upon the competition, and we have the competition overseen by a lay observer from OCPA. Right, sorry. The position, as I understand it, in relation to FMDFM, is that the list of appointable names goes up to them, and they choose whoever they want. And I'm not suggesting there's anything wrong with that approach, because from their point of view, they will want to ensure, that is the political involvement, if you like, they will want to ensure that the people that they get are people that they feel will represent the public interest in the way that they want it represented. So there is some degree of ministerial involvement, but this process was designed to reflect the fact that we are emerging from a period of conflict, that where that is the case, until we move on, that the Lord Chief Justice was the right person to chair NIJAC, and as it happens, that has been fastened by the view of the Commonwealth Lawyers Association, which is not just some bunch of lawyers. I mean, it's chaired by James Dingemans, who's a High Court judge. It's very widely respected throughout the world, and the model constitution touches not just on judicial appointments, but on other aspects, and in broad terms is the baseline for anybody who's looking at revising the constitution within the Commonwealth. So I think that what we have actually represents best international practice at the moment.
When you say, in reply to the question, at this stage,
Yep.
Can I ask you, what are the circumstances in which you believe there would separation of the two positions would be sensible?
I would have no issue about separation of the two positions in circumstances where we had got to the stage where the Minister of Justice was appointed on a straightforward basis, initially presumably to Hunt, and where the Hunt ended. So if we had a legislative move which didn't require the Hunt there anymore, I think there'd be a case for saying that is a sign that we've moved on and that we've come out of conflict rather than emerging from it. And in those circumstances, although I would still ask anybody looking at it to recognise best international practice, I wouldn't have anything like the same concerns about it.
And so, in that context of the Hunt being triggered and justice being addressed in the way other ministries are addressed,
And Hunt out of the way. Yeah.
who then would you see as being the chair of NIJAC?
The way in which it's done in England is that, unlike the other lay members, it's an open competition, in which I suppose the Chief Justice could apply, unless he was excluded. And I'm sure he would be treated fairly in whatever process was undergone. The layperson, the chair who's appointed on merits, presumably under the Commissioner for Public Appointments process, is then scrutinised by the Select Committee of the Ministry of Justice. And the scrutiny is to decide whether or not it's accepted that the chair is independent. And it seems to me that they must have a mechanism then for ensuring that there is a no vote from even a minority if there was a lack of independence. I think all of that, of course, raises the spectre that you would sit for a very long time without a chair if there were a series of no's. Just as I'm sorry to say, I have sat since June of last year, one layperson less than I ought to have, because although 3 names or more went up to the FMDFM in October 2013, and although I have written to the FMDFM asking where on earth my nominee is, I think apart from an acknowledgement, I haven't had a response.
Thank you.
Mr. Elliott.
Chair, thank you, and thanks very much for your presentation. And apologies for this first, because I'm going to go back to something Mr. McCartney was highlighting. But it is difficult to, I suppose, move away from Judge Mariner's case and what would be a general issue. So we're going to try to generalise it, and that is around the guidance. And you did say, Lord Chief Justice, that provided there was no breach in procedure, that it wouldn't require any further action.
No, I didn't. I said that you'd have to look at any breach of procedure, see what the consequence should be flowing from the breach.
Yeah. It's just, obviously, in the Ombudsman's findings, he did find that obviously he felt the guidance wasn't followed fully.
In relation to?
In relation to the moderation process.
Yeah.
And I think you said you accepted that.
Of course.
In
if
fairness.
as you can see in the papers, I've accepted
But
that.
the thing I'm trying to do is separate the difference between a breach in procedure
Yeah.
and the difference in guidance.
Yeah.
Now, just...
But the breach of procedure is the breach of the guidance. The two are the same.
Okay.
Because the guidance sets the procedure. The breach was not concluding in the way the guidance required.
So, are you saying that is a breach of procedure then?
I'm saying there was a breach of procedure, yes.
Okay.
And the point I'm making is, where there has been a breach of procedure, you then have to look to see what is the nature of the breach and what consequence should flow from it. And we do this all the time in all sorts of employment cases, in all sorts of governmental issues, where the question arises where there has been some breach in procedure, what is the consequence? And what you have to examine is, generally, is if the breach, but for the breach of procedure, what would have happened?
And sorry, can I ask then, what follow-up was there to that and what consequences was there?
Well, there was obviously a finding, but if you actually then look at what was the breach of procedure, the Ombudsman considered that there was no question of maladministration as a result of the breach of procedure. And the reason for that, it seems to me, is that the Ombudsman saw that all the material was there to enter the figure in the quality. It's obvious what the figure should have been. It simply wasn't entered. It should have been entered.
Okay, appreciate that. Just as a follow-up then, do NIJAC take any further actions in their processes
Yes.
to try and overcome that for future
Yes, and
process? Because that was my next question.
Well,
was
that's why we...
the review, sorry, just
Yeah.
if I could finish.
Yeah, sorry.
That was my next question around your review of your own processes, and do you take any examples from other jurisdictions like Wales or Scotland
Yeah.
that may be helpful?
Yeah, I mean, we spend quite a lot of time engaging with Scotland and England and Wales. For instance, the Chief Executive, our new Chief Executive, and one of our commissioners went over to a very interesting diversity conference that was held in Scotland about 2 months ago.
Yes.
Yeah. I mean, as with all of these things, it's the discussions you have on the side that very often enable you to start thinking about things that you should be doing or things that you could be doing. We've also, I've met Christopher Stevens, who's the head of the English JAC, in January at a conference which we both attended. We both participated in the panel. I've met the chief executive of the JAC in England and discussed with him aspects over some issues we were having about large numbers of applicants coming from posts and what's the best way to shortlist, which I brought back to the chief executive, and we are at the moment are in the process of discussing at NIJAC. And of course the document that Mr McCartney referred to, which is dated November 2012, just didn't emerge out of the air. It was a product of a recognition that we needed to put together clear advice for those who are involved in the process about the things they should do, and that was intended to and did reinforce with those who are involved the need to ensure that they complied with the procedures.
Okay, so that's the wider review, Chair, just dealt with. What about the specifics, like if the issue that was identified where there was a breach of not following through on the moderation? How is that dealt with then?
The Ombudsman, that's the Ombudsman's task. The Ombudsman's task is to examine any breach or complaint that has occurred and to determine whether or not or what the outcome should be as a result of that. And the Ombudsman concluded that the breach which he found, and which in fact the Complaints Committee found, did not amount to maladministration.
Yeah, but I'm assuming, sorry, that was in that particular case.
Yeah.
But you wouldn't want to have that breach continuing through other cases.
Oh, no, and that's,
so I'm just wondering if there are mechanisms. What I'm trying to get at, are there mechanisms within NIJAC to actually make changes where there are found to be procedures not that,
yeah,
or guidance that wasn't followed properly?
I mean, one of the things we do with every selection team is that we go through a process of ensuring that they are retrained on a regular basis if they haven't actually been working in the field, as it were. And if they are working in the field, one of the tasks for the staff is to chase up, and we now do this, that the staff won't let you out of the room until you've actually completed the paperwork. It's a very effective way of doing things, but it makes sure that everything gets done.
Okay,
because you hand the paperwork over to the staff will look at the paperwork, and if there's something that's not done, you get it straight back and you don't get out.
In this particular case, and you might not be able to answer this, was there an explanation sought as to why it was completed?
I think the only explanation is the explanation that is contained in the papers that a conclusion had been reached. I mean, I think the conclusion had been reached because they were in an obvious position of equality that they were going to have to move on to the next round. I think that's the reason.
Mr Dixon.
Chair, thank you, Lord Chief Justice, for being so frank and open with us, and one would expect nothing less, because that's what you've said to us right from the very first time you visited this committee.
Well, thank you for that.
In his letter to the committee, Mr Marrinan goes on to say that he suggests that it is not unreasonable to suspect that there may be another reason in play with regards to his failure to be appointed. That the obvious one, that the matters that he drew to the committee's attention about NIJAC's behaviour are so serious and demonstrate such a high level of unfairness that, in his view, having demonstrated that level of unfairness, that effectively what is happening now is that people are seeking to avoid to be made accountable for their behaviour. How do you address that comment?
I obviously haven't seen the letter until today.
I appreciate that.
It felt necessary to show it to me, although I see it was received or dated yesterday at lunchtime. But I don't accept. I understand that the judge has a perception that he was treated unfairly. I think he's just got that wrong. But I understand that he has that perception. I understand that some of that perception arises from what happened at the end of the first round of interviews, as it were. You'll see that the judge complained about the fact that he was being asked to produce written work. that he felt that as a result of that there should have been recusal. I understand all of that. The request for written work, of course, as a complaint wasn't upheld, and that's hardly surprising because the last County Court judge who was appointed to the High Court before Judge Martin was Sir Anthony Hart, who had 250 pieces of published judgments and rulings from which he could have selected any as examples of work. I don't really want to go into, despite what was in his application form, what the judge had. But I hope that by coming here, that I've made it plain that actually I think it's important that NIJAC is accountable.
Yes.
And I also want to make it plain that in my correspondence about whether it was this committee's responsibility to carry out the scrutiny, that in case it wasn't planned, that in my view that scrutiny should have rested, as it did with the Ombudsman, and also with the Select Committee of the Ministry of Justice, because it's their job to scrutinise the Lord Chancellor's political decisions, and he was politically responsible for this competition. I mean, I know you disagree with that, and that's fine, but I'm simply alerting you to the fact that if anybody thought that it was because I didn't want there to be accountability, they were completely wrong. It was a question of who should carry the accountability out.
And in respect of the Ombudsman, and this is in general terms, if any Ombudsman for any sphere of public office, regardless of whether it's judicial appointments or other public sector appointments, would you agree with me that there are effectively two levels of information and advice that come from such Ombudsman? One is in terms of learning experiences, which there may be a small number of here, and there are others which are so substantive that they do have a major effect on the outcome of whatever the issue is, and that in these circumstances these are rather learning points rather than anything more substantive.
Yeah, I think you're absolutely right about that. I wonder, could I just, because I know you're looking at this in the context of a review, if I might make one other point in relation to the Ombudsman. I think myself that there's an awful lot to be said for a role for the Ombudsman in a governance mode. In other words, examining not only by way of complaint, but examining generally the work of a body like NIJAC, and bringing, not just in terms of complaint, but bringing suggestions as to best practice, if you like, on an ongoing basis.
Yes.
I mean, I can't possibly see what objection any organisation could have, for instance, to an expert reassessment of how well or how badly they're doing their job every year from an outside source. And if you are looking at arrangements, can I suggest that you take that on board and consider whether or not you think it might be helpful?
Thank you very much.
I'm assuming now if there was a complaint about a current application, you wouldn't have the constitutional issues about this committee looking into it?
No, I don't think I would. I mean, I can't see that, and there would be the same difficulty at all.
Okay. Mr. McGuinness.
Thank you very much, Chair, and thank you, Lord Chief Justice, for coming. I think it's been very helpful, and you've covered a number of points which one wouldn't have anticipated you would have covered.
It sounds as though I'm breaking the law on my own part. I mean,
Perhaps you are.
If you're going to find me guilty, Mr. McGuinness, then I suppose you better tell me what the penalty is going to be.
But could I say that is helpful, but we could have had this discussion earlier.
I agree. I mean, we could have had it on the 14th of November.
But given the correspondence that took place between your
the
office,
correspondence of the 24th of October expressly said that I was happy. In fact, I have it here, that I was. I mean, I don't want to get into this discussion, but I mean, the point I was hoping that I made in the letter was.
It was a simple available to meet on the 14th or 21st of November. It was a...
Yeah. I mean, I don't think it can be clearer than that.
Although we did respond indicating
Yeah.
we wanted to do
Oh, no,
preliminary
I
work.
understand, but
We
if the
wanted
point
to
is-
have
if the
Lord
point is-
Justice Coughlin.
But if the point is made to me that I'm a bit late in coming, I think it's because I've been a bit late in being invited.
Well, you know, the correspondence
I
indicated.
don't really think it's
We'll leave it
going
at
to
that.
help any of us.
I'm a bit disappointed with your response to Mr. Humphrey in relation to the chair of NIJAC. It seems to me that confusion of two positions, two important positions, Lord Chief Justice and chair, is not a healthy one. I think that can lead to difficulties, and I think it may have led to difficulties in this particular competition we're discussing. And I would put the proposition to you that even though perhaps we haven't matured as politically as one would like, that the appointment of a lay chair would be preferable in order to avoid any confusion in terms of the office of Lord Chief Justice, to protect your office, to protect the integrity of the office and so forth. Is that not a fair point, Lord Chief
Well,
Justice?
I understand the point, Mr. McGuinness, and I can understand that somebody may take that view. Can I suggest that if you are considering that option, that you look at the model constitution proposed by the Commonwealth Lawyers Association, and there are a number of papers which discuss because they did anxiously examine the issue of where this responsibility should lie, and there are a number of reasons advanced there. And I think as an issue, it's one that requires careful consideration. And can I suggest that perhaps your secretary might be able to gather together the papers and you could look at the reasoning, and if necessary, I'm sure if anybody was to write Mr. Dingemans, who I've always found very helpful in relation to all of these things involving the Commonwealth, I'm sure he'd be more than happy to give you a steer as to why the Commonwealth lawyers came to the view they did.
Yeah. Well, I think
I'm just looking at international best practice.
yes. Well, I think that's very helpful,
Yeah.
and I'm sure the clerk will take that on board, and the committee will take that on board in due course. But you would not rule out a lay chair. It's a matter of timing. That's really what you're saying.
I mean, Scotland and England and Wales have lay chairs. I mean, I'm not. I mean, as I say, my view about this would be very different in circumstances where the politics have become different.
Yeah. The other point that I suppose it's a point that was has been raised before in this committee when considering NIJAC, and I think the attorney made reference to this whenever he was giving evidence to the committee, that he felt that the senior judges, including your good self, had too much of an influence in the appointment process. In order to counter that, in order to rectify that, would it not be appropriate to reduce the judicial element and to have more of a lay input into the actual appointment process?
Well, first of all, can I maybe just look at England and Wales? England and Wales has 5 lay members. It has 5 judicial members. It doesn't include in its judicial members the lay magistrate and the lay tribunal members. So in fact it has 7 judicial members and 2 people from the professions. So that the lay representation in England and Wales is, on one view, considerably less than we have here. The balance is actually not markedly different at all, even with the lay chair, from the balance that we have here. And I mean, I do think that, you have to take into account the way in which we operate. The fact that the chair of the committee which is going to appoint the next High Court judge, whenever that arises, is a lay person doesn't happen by accident. It happens because we value the lay people And the lay commission, the chair of the committee, as you know, has a range of responsibilities, but also a range of rights, including a casting vote at the end of the day. Both of those chairs that I referred to in the County Court and High Court competition are women. That wasn't by accident either. That was something that we deliberately put in place. And I think the point that I'm trying to get across is that the attorney asserted that there was undue influence by senior judges. I am not aware of the attorney ever setting foot inside NIJAC at any stage in his career. I brought Ruth Laird, who is a lay member, to this committee in March 2012, and would ask you to think about reading her evidence again. But so far as the pertinent points are concerned, let me just read you what she said. She said, after explaining what she did, she said, I want to dispel any notion that our contribution is less than effective. I also want to dispel the notion that we are dominated in any way or unduly influenced in any direction. The absolute rigour of our debate can be well demonstrated to anyone who wants to attend the Commission's meetings. And she, as I understand it, is the only lay member that this committee has ever heard evidence from. So where is this evidence that there is any undue influence by senior, junior or other judiciary? The answer is that there's none. On the question of the committee maybe having seeing us in action, as it were, it just reminded me when I read that. We've changed our method of working slightly, or at least we're going to change it from October on. And what we're now going to do is to have a business meeting in the morning and a themes meeting in the afternoon in order to look at policy issues. First of those is around the High Court competition, but we're setting up at the moment a theme meeting on the afternoon of our February 2015 meeting to look at diversity. And the theme meetings are meetings, because we want to think of this as part of our outreach, the theme meetings seem to us to be opportunities for those who are interested to come along to participate in and hear the debate. And then maybe you can go away and tell us whether or not the senior judiciary are having an undue influence or not. But let me make it clear that there is a standing invitation to any member of this committee who would like to come to our theme meeting on diversity to attend. We'd be delighted to have you or some nominees or members who would come along. The diversity issue is one that seemed to us to be extremely important, and we would be delighted to have the contribution into the debate of members of this committee.
I might take you up on that.
Yeah, well, we will even buy cake, Mr. McGuinness, albeit that I'll have to buy it myself. But
We might bring some with us.
Can I maybe just add something to that? I think the concern from my perspective in the administration in relation to a perception of the involvement of the judiciary. On the other side of the coin, we're working very closely with the legal community, medical members and others that come forward. And the concern that they have is that we are a HR function with not sufficient appreciation of the role of the job. And I think, therefore, it's important to think that the panel has to look both at the specifics of the job along with the HR function of interviewing someone on a competence-based process. So for us, it would be quite difficult to try and not use the judges because of their role in knowing what the expectations are. So everyone has to try and balance the different assessments that they're taking from that process.
Thank you for that. I don't want to go over well-trodden ground, but just in relation to a question that the Chair put to you about Section 5.6 of Part 1 of the Justice Northern Ireland Act 2002, looking at it, and if I could read the relevant part of it, says subsection 6A, after doing so, either reaffirm its selection or select a different person to be appointed or recommended for appointment. It does strike me, looking at that there is no room for as it were, recommencing a process as was the action taken by NIJAC?
The term recommencement has been bandied about. I think it's quite important to look at what, in practical terms, did we do. What we did was we opened the competition to anyone else who was qualified to apply. That was what we did. It wasn't that we, and that's why the term recommencement is quite difficult. If you can find for me the word that describes opening the competition to other candidates, I'm happy to accept that in place of recommencement.
But the net question I think that the committee is struggling with is in a situation where you had effectively a two-horse race, where one horse was disqualified. I don't mean that offensive in any way, but the one candidate was not acceptable to the Lord Chancellor. In that situation, you had one other candidate left who was suitable.
Well, there never was a finding in that. That's part of the difficulty here, and part of the reason why we've now changed our practice. Our practice now is to define the appointability limit, and the appointability limit in previous competitions was determined after the successful candidate was identified. There was then, is there any reason not to appoint this candidate? And that was the approach. And it wasn't, in my view, the best approach. But the difficulty always was, well, I say the difficulty. The other thing to remember is that a selection committee always had the option of appointing a reserve, and it didn't do it in this case. There were only 4 candidates, only 3 of whom made it through the SIFT. Once the other candidate was out, there were only 2, both of whom were male judicial office holders. Our obligation under the statute is to seek to promote diversity and to make sure that we get the best candidate who's available. And at the time that we came to make the decision, what we were faced with was, in effect, should we have excluded the 11 people who applied in the next High Court competition, who were all there waiting to go? Because, and that's what the public interest was about. Or did the private interests of the judge outweigh our public obligation? And we took a view about that. People may take another view. The judge undoubtedly did, but that was the view that we took.
Well, I think the committee might struggle with that.
Well, it may do, but I mean, the other side of this, Ms McGuinness, is that if we turned round and appointed the sole remaining, if you like, judicial office holder, then I can assure you, I don't know which papers it would have been in, but it would have been judges appointing judges. I mean, that would inevitably have been the other approach. Now, that's not the reason why we made the decision we did, but there's no point in pretending that no matter which way, this was a difficult decision, and no matter which way you look at this decision, it was always going to be a problem.
Thank you very much, Chair.
Okay. Mr. Anderson.
Thank you, Chair, and thank you, Lord Chief Justice, for coming along today and presenting to us. In your description of Ryan and indeed all your judges, I think the terms you used were they're all very good, hard-working, respected judges.
I have the utmost respect for all of them.
Yeah. That being the case, and I don't want to delve too much into this letter, but with so much respect, why should you or anyone need to write to one of those respected judges stating that you're reminded to take disciplinary action?
Because if somebody denigrates the integrity and courage of my judicial complement, who else is going to take issue with the person who does that? I mean, it's my job to stand up for the integrity and courage and independence of my judges.
Have you changed your opinion in any way? in relation to this? Have you changed your opinion of Judge Murray in any way in relation to this?
I think that I think he probably made the comment without having thought it through, and he has indicated to me that he did not intend any disrespect in the correspondence he sent back to me. And as far as I was concerned, that was an end of the matter, because it's clear to me that although the correspondence may have suggested to you that the judges would not have been independent and courageous enough to make whatever decision was required, that his correspondence to me seemed to me to indicate that he was not in any way seeking to denigrate those people.
Yeah,
And I was satisfied with that.
You used the term, maybe you got it wrong. Would it not mean maybe a difference of opinion rather than getting it wrong?
No, it's not a difference of opinion when you assert that independent judges of integrity would not give you a fair hearing. I'm sorry, that's not a difference of opinion. That is a statement that goes to the very heart of the rule of law.
Okay, I'm just trying to get my head around this.
Yeah, no, I understand.
As the Lord Chief Justice, and the respect that you had for our Judge Murray and your other judges. You talked also about somewhere along, maybe at the end of the first process, of being asked, Judge Murray being asked for written work. Could you expand on that? Was he aware from the outset, along with others, that this was part of the condition or the criteria?
No, what happened was that as you'd have seen from the papers, what happened was that when they decided they should proceed with a second assessment, they had to decide what assessment tools they were going to use. So, because in the High Court, as you can understand, I mean, you have to write a lot of judgments. I mean, I wrote, I think, 58 judgments last year. I've written already 26 judgments in this calendar year. One of my judges has written over 30 judgments already this calendar. I mean, you need to be able to write. You need to be able to write well, and you need to be able to write expeditiously as well. I mean, you can't muck around and fail to get the judgments out, because that deprives litigants of what they're entitled to. So, perhaps not surprisingly, because of certain comments about the extent to which he had judicial work available, not unsurprisingly, it was suggested by the selection committee that one of the assessment tools might be 2 pieces of written work, and the judge then wrote to indicate that he felt considerably disadvantaged by that for the reasons that he gave. And the selection committee then wrote back and say, and he asked them to recuse themselves as a result of that, and the selection committee wrote back to say, well, all right, we won't ask for pieces of written work.
So that didn't affect him in any way by not agreeing to submit written work? That wasn't considered?
No.
That's okay.
I think from my own point of view, I think the ability to write judgments expeditiously is an extremely important part of the job of a High Court judge, and I would not want you to go away with the impression that I would oppose that being used as an assessment tool in future. I have actually gone to my Crown Court judges as a result of this and said to them, write and put it on the internet, on our internet, so that people can see the work that you do. I mean, Sir Anthony Hart, who was a very, very busy judge, could still produce 250 judgments. And there are many of my younger judges whose judgments are now well into double figures. I mean, they having had the encouragement that I've given them, I would think that they would find it very hard to say that they were disadvantaged now if somebody wanted or thought it proper to use that as a tool.
Okay. In your opening remarks, if I remember clearly, you talked about improvements have been made in the processes, and that you have learned from past experiences.
Yep.
Has anything been learned from this process?
Yes, I mean,
What would you say would be?
I mean, among the things that have been learned is the redrafting and issue of the document in relation to the selection committee. is the involvement of the staff in ensuring that there's adherence to the procedures. There's a recognition of the importance to be attached to that. There's a recognition of the importance that the Ombudsman places on a separation between NIJAC and the Chief Justice's Office, which is why I'm here with the Chief Executive from NIJAC and my legal advisor from my own unit. So all of those things we have sought to take on board. We're also conscious of taking other steps which I think will help in relation to this. I mean, I'm keen on a kind of a roadshow where you're coming up with the prospect of senior appointments. So that if we were looking at a High Court appointment, I would be quite keen to roadshow it with the pool who generally would come forward, the solicitors, members of the bar and the members of the County Court bench, and to roadshow it in a way which was trying to help them to present their applications in the best possible light. I'd probably end up having to do quite a bit of it myself if that's the route that we go down. But there are, I think, obligations on us to make sure that we reach out to the appointable pool and make it clear to them that all of them are welcome to apply and that we are anxious to have the best possible people.
You talk about, I think, 2017, a number of vacant positions of maybe 6 or so. Do you see those that getting out to those people?
Yeah, yeah.
27 rolling out before then?
Well, that's what I would like to do. I mean, potentially, depending on the circumstances, potentially 3 of those might arise between now and the autumn of 2015. Potentially 3 further positions might arise by the autumn of 2017. Now, if we go down that route, I think it might be quite helpful if we had 3 positions all at once to come forward. And there are always ifs and buts around this, but if we had 3 positions coming up at once, it would be an extraordinary opportunity to get out there and talk to people. And I, for instance, have been a strong supporter of a process of involving women at the top end of the legal profession, which has been going on now for about 18 months. I talked to the President of the Law Society about setting up a Women in Law project, which involved a series of lectures given by women on a whole range of important subjects. I then talked to the Family Bar Association of the Bar and persuaded them that they should engage in something of the same, and they've just completed a 4-lecture series in this as well, showcasing the best women and then getting solicitors and barristers in to realise and recognise the respect that ought to be paid to those people. And I want to go back out to all of those groups if we do have a High Court competition, and to encourage them all to think hard about whether or not is the time for them to come forward.
Thank you, Lord Chief Justice.
Okay. Finally, Mr. Lynch.
Yeah, thanks, Chair. And you just touched, Declan, on the point I was going to raise about women. And I know we brought it up the last time. I wonder, have you looked at the practices in the south of Ireland, where they have been very successful in appointment of women?
Well, I think on the last occasion, or maybe it was the first occasion when I came here, I indicated that I had actually gone to talk to Susan Denham about this. And one of the things that two things that she told me about which I thought were helpful. One was that she said you need to have what she called a sisterhood. In other words, that the people who were prepared to get to not just look after themselves, but to look after others as well, and to create that type of atmosphere. And the second thing that she mentioned was the importance of mentoring. Now, what we've done through the Women in Law project is that we have actually now set up a group of mentors within the professions. And the point is that that is there to help women who are at junior, medium and senior levels of the profession to think about how they should move forward. We've always had some difficulty in having mentoring through the judiciary, particularly the senior judiciary, because at the end of the day the High Court is a male area, and I'm not sure that it's as welcoming as it could be. The County Court has, with the appointment of Judge McColgan recently, has now a cohort of female judges. The district judges civil are 50% female. So we have, and some of those judges have participated in the mentoring process that has been ongoing. And I think mentoring is actually a very positive way forward in terms of changing culture, which is what I want to try to do.
Okay. Well, on this particular issue, Lord Chief Justice, because I know time's pressing, so we'll not keep you much longer, but if we can go on to the sentencing type issues. But on the issue of judicial appointments, can I thank you for your candid approach? I think it's better that we have the exchanges and flush out the issues and then move on from that point. And I appreciate the new dimension that you have brought to justice having been devolved in terms of your role as Lord Chief Justice and head of NIJAC, and I want to put that on the record that I do appreciate and value the approach that you've taken in respect of that.
Well, I'm very grateful for that, Mr. Chairman. It's very kind of you.
Yeah, thank you. In terms of, there was a couple of areas that we had touched on that we wanted to speak with you about, and that was one on animal cruelty and then also attacks on the elderly. So animal cruelty is one where there's been a bit of media attention to that of late and public concern in respect of the sentences that are being administered for this. Is it an area that you've had to look at of late, given the public attention?
Well, what we've done is that I have identified, as you know, I have set up a sentencing group back in 2010 in order to develop policies in relation to sentencing, to reach out to other areas that maybe weren't reached before, but most importantly of all, to ensure transparency about how sentencing is approached in this jurisdiction. And since then, we've had 35 Court of Appeal sentencing guideline judgments, we've had 6 Crown Court sentencing guideline judgments, we've had 104 Magistrates Court sentencing guidelines, including guidelines on animal cruelty under the Welfare Act of 2011, and we've had 4 sentencing case compendia which are dealing with food and tobacco smuggling, tiger kidnapping, child cruelty and intellectual property crime. But I have to be, again, careful. I seem to spend my life saying that in this committee. I have to be careful because I can't talk about individual cases. But at the moment, I'm aware of only 4 prosecutions which have reached the courts under the 2011 Act, 3 of them in the Magistrates Court and 1 in the Crown Court. I think it is important to understand that the justice system and the criminal justice system is a joined-up system. Everybody has to understand their part and be able to play their role. That includes the judges. And we have to do, it seems to me, there has to be, and may need to be, some mechanism of ensuring that everybody understands each other's position. Let me give you an example of that. I recently organised a joint training session between the judges, the Bar and the Law Society. The topic was the way in which vulnerable witnesses, particularly in sexual cases, should be treated in Northern Ireland, because I was determined that we should not have a repeat of the ghastly scenes that had occurred in cases of that sort in England and Wales. And it seemed to me, a mechanism of getting the message across to the professions that they were going to have to approach this in a particular way, and if they didn't approach it in that way, that they would expect the judges to come in on top of them like a ton of bricks, and maybe that the Court of Appeal wouldn't be particularly receptive to people who were complaining about the fact that they had done so. And that's an example of trying to think a little outside the box instead of just sitting in court and waiting for a case to come to you. Looking at the, and I can only really look at one of them, looking at the case that went to the Crown Court, there are a number of things that struck me as really quite odd. There were 23 counts on the bill of indictment in that case. 19 of them were not proceeded with by the prosecution. I don't know what the reasons for that were. There were 7 defendants, 3 of whom were not proceeded against by the prosecution. I don't know what the reasons for that were. Only 4 of the counts were actually proceeded with. It did strike me that where you're bringing a case to court, you need to ensure that those who understand the issues and are experienced in relation to them, such as those who have been appointed by the councils, I think, to do this. There are maybe 9 specialist investigators who have been appointed. You need to make sure that they also understand about evidence gathering, not just finding the incident. They've got to understand about evidence gathering. So the process of taking forensic evidence, of interviewing, of having an interview strategy so that it's effective in terms of securing, where it's appropriate, admissions. A prosecution service that is able to give direction about further investigations that need to be undertaken before the case comes to court, to make sure that when the case comes to court, it's in good order. In the sexual area, you tend to have specialist teams who do that. Within the PSNI, for instance, there are specialist care centres which look after women who are assaulted or affected in that way. And I couldn't help thinking when I looked at that case, I just wonder how much coordinated thinking there's been in relation to the way in which these cases are presented. So I leave that with you.
No, that's very helpful, because it often people will say, right, we need to go back and look at the legislation, and we did only recently legislate on this issue. And there's a response to say, well, maybe we need to increase the sentences, or do we need to give the director the power if it's an unduly lenient sentence? But in essence, what you're saying there is we could increase the framework, but if you don't have all of that work going on, it won't really make a difference.
And to be fair, we've only had 4 cases, and there may be a learning curve, as there is with a lot of things. But I think it would, I think before I'd say an awful lot more, I think I'd be quite interested to have all of those areas explored to see whether or not, there maybe was something in them.
Okay. Mr. McCartney on this one.
It's just on the point, you talked about it being joined up, which is an obvious observation. What role would a judge have where there are 21 or 23 charges and 19 aren't proceeded, 7 defendants and only 3? Can he ask or she ask appropriate questions in relation to it?
It's difficult because the judge is not the prosecutor, and the moment, of course, you start asking questions about why aren't you prosecuting this or prosecuting that, you can see the defendant's going to get a bit agitated if you're then going to hear the trial. The general rule is that the decision as to whether or not to prosecute is entirely for the prosecution service. A judge, if on the papers before them it's clear to them that they think it's a very unwise decision, a judge on the authorities can say, I think you should have this reviewed. In other words, can say to the prosecutor, in effect, go back to the DPP and ask him whether he really wants to do that. But, of course, that would depend on papers actually showing the judge that these concessions were concessions that shouldn't be made. And what the judge doesn't know is whether the witnesses on the paper saying that X, Y, and Z happened has actually gone into consultation with the PPS and said, well, actually, it wasn't there. And that's the bit you don't know.
Again, I don't want to stray, and we're all cautioning ourselves about being careful, but where, say, in a case, a person makes no mitigation, the mitigation is accepted, but then when they leave the court very openly and very frequently, they just ignore the mitigation. Is there any room there for contempt of court? Or
I don't think so. There would definitely be contempt of court there might be contempt of court if somebody said, well, that judge wasn't an independent and courageous judge or something of that kind, because it may be possible in those circumstances to deal with that as a contempt in the face of the court. But the circumstances in which you can actually do that outside the court are very difficult. If you did it inside the court, then you would be entitled to take action.
Thank you.
Ms. McCorley.
And thanks very much for coming to the committee today. Do you see, in relation to you were saying about people not maybe having their work done appropriately and at times, and maybe not coordinating properly with other agencies and all of that, resulting in these scenarios that actually are very damaging, because the public just take the view somebody got off. They did 19 very wrong things,
Yeah.
and they've got off scot-free.
Yeah, I agree with that, yeah.
And it's very damaging to the justice system.
I agree.
And the people who work within it. And do you think in those circumstances there should be penalties imposed on people who are at fault in how they're carrying out their work?
Well, I think the question always is, what do we want to do? Do we want to spend time finding out whether somebody has actually got something wrong or made a mistake, or do we want to retrain them to make sure that they actually don't do it again? And I think if you're looking at a limited resource, all I can say is I can well understand the argument for saying, look, the important thing here is to get the right people trained up to do the right job. And that, I think, is... I'm not saying it happened in this case because I don't know sufficiently about it, but the first thing I would do if I was in the position of some of those involved in that case, I would have done a lessons learned exercise in relation to why all of this happened, and would have reviewed procedures, maybe even got the Ombudsman in to see whether or not they could help with, look around for help. I wonder, how is this dealt with by police and prosecution divisions in England and Wales? Has somebody gone to talk to them, because they've had an Animal Welfare Act in place since 2006? Has somebody gone to talk to them about the way in which these things are prosecuted, the way in which they're investigated, the evidence gathering that goes on and the mechanisms, whether they use specialist teams to do it? Maybe they have, but that's I think would be, in my view, the focus of the way forward. But then I'm not an expert. I'm just a judge.
Okay, and do you see, in terms of lessons learned, are you saying that that's your approach then, and that you would look at maybe areas where you feel, right, there's something went wrong there, and you might know the detail, but you have an instinct that there's an area there that needs looked at?
Well, if I felt that it was important for us to examine lessons learned in relation to the judiciary, we would do that as quickly as possible through the Judicial Studies Board. We have a mechanism of doing that, and I regularly encourage those who are in the Judicial Studies Board not to get so excited about the more esoteric aspects of European Union law, or perhaps the very latest case on contract or whatever it is. The important thing, I think, from my point of view, is that we give judges the practical tools, the everyday tools, to actually get on with doing the job effectively. So things like addressing the jury in a way that the jury are going to understand, so that they will understand the way in which the case has progressed and the importance of the evidence, is a lot more important than looking at those esoteric points.
Okay. Just one question in relation to the animal cruelty issue. We have... there's been public outrage, and everybody knows about a particular case, but in general there is outrage that these there are offences which aren't dealt with stringently enough. What would you say to people who say that, because they're saying it to us, that there should be like up to 5 years, as is the case in America and the south of Ireland?
It's entirely for the legislature. It's nothing to do with me. If you decide to do it, that's fine, and we will impose sentences accordingly.
Okay. All right, thanks.
In terms of the attacks on the elderly, there has been debate for a while about mandatory minimum sentences. From your experience, is this an issue that the Assembly does need to be looking at, or is there any evidence to suggest that when these cases are brought to the courts that the appropriate sentences aren't being given?
Again, I think this is an area where, if I may say so, that there may be room for thinking about a joined-up approach as well. I think that one of the things that sometimes is not appreciated is the effect on the elderly, not just in terms of any physical effect there may be from an attack, but the way in which the confidence of an older person can be completely undermined as a result of an incident which might on its face seem not that serious, such as somebody spending too much money on a roofing job or getting their paving area redone and finding that they were defrauded in the sense that they paid too much. The effect on elderly people, and I've seen this myself, the effect on elderly people of finding that they were conned, if you like, in that way, quite apart from physical attacks, can, I think, be extremely significant in terms of the quality of life that they enjoy. Now, there is where I think the importance of having good victim impact statements is absolutely critical, because in all sentencing, harm is an absolutely critical aspect of sentencing. We had a case today in the Court of Appeal, which was a bad case, but we passed a sentence, or we affirmed a sentence of 14 years imprisonment in relation to a rape and other sexual offences case. But the reason that the case attracted the sentence it did was because there was good evidence of harm to the victim, which was an extremely important aspect, and which for us was a major factor in taking the view that we did about the case. And I wonder whether, in relation to the elderly, there is something to be said for, again, in making sure that the police officers involved who are looking after these cases are looking for the psychological impact just as much as they're looking for the physical impact. I think where the evidence is, the evidence that I have, in a way, is that that broadly I believe that the judges are following through. And if it's of any help to you, I sent one of my legal unit, who actually is also a deputy district judge, to the Pensioners' Parliament, which was looking at the question of impact upon the elderly. And he did a presentation in relation to this, along with Claire Keating, who's the Northern Ireland Commissioner for Older People, and talked about what the position was from the legal side. And they discussed the question of statutory minimum sentences, and the Commissioner for Older People indicated that treating the elderly as a specific vulnerable group, which was then an aggravating factor for the offence, was a better way forward than a statutory minimum sentence. So, I mean, we have, I think we should look again to see if we can find an up-to-date sentencing case in relation to attacks on the elderly. We have a case which demonstrates that in circumstances of significant attacks, that sentences of 15 years as a starting point would be appropriate. I think it is always important to say that 15 years is a starting point. I mean, if somebody comes in with a record on top, or with any indication of other activity, then it would go up quite considerably.
Okay. Any other members, any other questions around sentencing?
Just very briefly, just to comment on the point which the Lord Chief Justice has made. And in a sense, it is, what you've said has been very helpful, because what a judge doesn't know is not going to influence how he or she sentences. And therefore, it is vitally important, Chair, I think the point was very well made, it is vitally important that in producing victim impact statements, that the whole impact of the offence, and not just, as the Lord Chief Justice says, a broken arm or a black eye, has the impact that it is. For example, in this selling to people, the deep psychological trauma that has, it's somebody saying to themselves, well, 10 years ago I would have never been conned like that, and they are really have their confidence shaken in those circumstances. But unless the judge is told, it's not going to affect the sentence. Thank you.
Mr. Elliott.
Chair, thanks, and thank you for that. Just on one issue, that has the probation board any further role to play in relation to that?
I'm just wondering, in terms of the offender?
Well, obviously in terms of putting a more accurate report, or a more substantial report, or a report that is more reflective, and I don't know.
The probation service,
I
don't think the probation service interview the victims. No. They interview the offender, but they don't interview the victims.
But is there not a victim service through the probation?
There is a victim service. There is a victim service, and it's their responsibility. Sorry, I'm thinking of the pre-sentence reports, which are prepared for the courts. by probation service don't interview the offender.
Okay.
But there is I think there's a focus now on victims which there maybe wasn't in the past, and there is a victim service which assists with the preparation of impact statements. And it seems to me that there's definitely work to be done in terms of communicating to the courts the impact of these offences on elderly people.
But there may be a mechanism there for doing it through the probation board?
There could be. Through the victims element
Yeah.
of the probation board, there could be. That would definitely be worth following up.
Okay. Chief Justice and your team, can I thank you for once again making yourself available to the committee? You've been very generous with your time, and we appreciate that.
Well, and can I, as it happens when I look back at the notes this time last year, indicate that I would be happy to come back to talk to the committee about whatever happened to be the matters of controversy that may trouble you in a year's time, if that was of assistance to you. So thank you very much.
Okay, members, the next item will be dealt with in a closed session. We'll just move into closed session.
I didn't want him to get too kind of made for He didn't get it. This is the Northern Ireland Assembly Committee Room.
By clause for the Legal Aid Coroner's Court Bill. And we agreed last week to ask the Assembly Examiner of Statutory Rules to attend to discuss the issues he's raised to several of the delegated powers and Assembly controls contained in the bill and the response from the Department of Justice. The Examiner is out of the country and therefore unable to attend the meeting. He did, however, provide further commentary regarding the delegated powers issue that he raised and is available to attend the meeting on the 11th of June. If, having considered the matters further today, the committee would find that helpful, and the pages are 15 to 111 of the meeting folder. The relevant papers and pages in the table pack is 853, which summarise the key issues raised in relation to each of the clauses and schedules. Provides the further comments of the examiner. In respect of the examiner's issues, he is still of the view that these are substantive and therefore should be by way of affirmative resolution in respect of the legal aid aspects of it. I would tend to concur with the Assembly Examiner in respect of the affirmative resolution procedure rather than the Department's preference for the negative resolution procedure. Is my own view on that. So obviously members will have their own views, but we'll go through each clauses and schedules in the order that they appear in the bill, and if members then can indicate their views on each clause, hopefully with the aim of reaching an agreed committee position that will be reflected then in the committee report. And once all the clauses and schedules have been discussed, there will be an opportunity to consider the Attorney General's proposed amendment. So if I can... And there's two tabled letters from the Department as well in respect of the Attorney General's amendment, and also to do issues that Mr McCartney raised in respect of the Law Centre's proposed amendments to the bill as well. So they just arrived before the committee started, so members can have a look at them. If I can refer members then to Clause 1 of the bill, and if members have any views or comments, it's around the dissolution of the Legal Services Commission and transfer of its functions to the Department of Justice. So I take members are content then with Clause 1 as drafted. Clause 2 is the designation of the Director of Legal Aid Casework. Members have any comments on Clause 2? If not, members are content then with Clause 2 drafted.
In relation to 2.1 we might, I think it could be better worded, but we'll just come back to that.
Is that around
A civil servant, yeah.
Sorry, what's that?
There was a rationale around specifying the director should be a civil servant or whether the post should be filled by a public appointment. There were issues raised around that aspect of the clause.
I mean, I think, that's not to say we might settle on this, but it might be better if it was, the department must designate the Director of Legal Aid Casework as a civil servant in the department, after his appointment or her appointment, rather than, I think it reads there, some people might just say that it has to be a member of the department gets this job.
Chair, I'm just slightly confused. Is it implicit or explicit in the bill? I'm not certain.
Look, I just think it's not, just for me, maybe it does.
Who must designate a civil servant?
Must designate a
But
civil
of course, that doesn't preclude the recruitment of somebody from outside who would then become a civil servant.
No, I think that's fair, but I mean, it's unclear.
But clearly, there is an issue there as to the standing of the caseworker.
The officials did indicate that there wouldn't necessarily need to be a competitive process, and there were a number of ways in which the post could be filled. The department outlined that were the person to be recruited, they would be appointed to the department first, and then the minister would designate the individual as the director. Would be a department's line. I'm content with the current clause as drafted. Are you suggesting?
No, at present we're okay, but I'm just making that reservation. We might amend it,
Okay.
but I mean, it's not going to hold the committee back at this stage.
Clause 3 then, I'm assuming other parties are content then as things are drafted. Clause 3 is the exercise of functions by the director. There was a number of amendments that have been proposed by the Law Centre to further enhance the safeguards around independence. The department's response was that they were satisfied that the current draft bill provided sufficient safeguards. The department was also concerned that the proposed amendments could have unintended consequences, and that's what's outlined in their letter to the committee, that could not currently be identified, and undertook to consider any potential negative impact for the proposed amendment. So, in terms of clause 3, as it's currently drafted, our members content? I'm content.
Again, we'll come back to it maybe in relation to the Law Centre amendments, but that will be at another stage. Okay.
Just the issue that was raised that I think is important by the Law Society and others was the fact that although the director could exercise his functions independently on an operational basis, that there could be policy constraints that could in fact impact negatively on the exercise of that independence, because there could be a category of cases and so forth, or a species of cases that would be excluded from consideration by the director. And there would need to be safeguards in relation to that.
This is where I think the department outlined that directions or guidance can't override the provisions of relevant legislation. Was there comeback on that issue around the classes of cases issue? That,
I think as a committee we need to be satisfied that that is a proper safeguard.
I think the department, in their response, it's on page 43 of your tabled pack,
Yes.
did outline what they say is the hierarchy of legislative materials and how that would work. That was their view. The guidance came below the primary and secondary legislation. Their response to it.
so I'm satisfied with clause 3, given the information the department has provided, or the guidance is secondary to legislation, so the guidance can't override what the legislation says.
Yeah, I just reserve on that, Chair. Yeah.
Are the parties agreed? Content? Okay. Clause 4 is designation of functions of the director. Concern was expressed that anyone in the Department of Justice who is involved in considering an application for legal aid funding, as well as those in appeals panels, should be legally trained. The Bar Council believe the current system of practising lawyers considering applications for legal aid and appeals works well, and that this should continue. The Department outlined that any staff involved in considering an application will receive the necessary training to discharge the function effectively and will have recourse to independent legal advice if and when required. Appeals panels would be made up of 3 people from a range of backgrounds and experience of the types of issues involved, with the lawyer as the presiding officer. Are members content with clause 4 then, as drafted?
Well, content with the idea, with the panel of 3, and certainly content with the lawyer being chair, but I'm not certain whether I'm convinced that lay members, non-lawyers, bring anything to the evaluation, given the fact that you're dealing primarily with legal issues which require a thorough legal understanding of the law and the facts relating to the law. I'm not entirely convinced that lay people are in the best position to do that. It may well be an exclusive panel of lawyers might be the better make-up for the panel.
Okay.
Content.
Well, we'll note your comments around that aspect of it.
Yes.
I'm content with the clauses drafted. Obviously, you can reserve your position on that aspect of it. Okay. Clause 5 was the annual report of the director. Is there any members, any issues around the annual report? No. Clause 6 was the amendment of law relating to legal aid, civil legal services and criminal defence services. Are members content with clause 6? Okay. Content.
Is that a purely technical amendment?
Yeah. Yes.
Yeah.
7 was the Lord Chief Justice to be President of the Coroner's Court. Are members content with that clause? Yeah. Yes. Clause 8, the presiding coroner. Members content with clause 8? Clause 9, there was no comments received. It was around the issues to do with application to the Crown Court, to the Crown. Members content with clause 9? Yeah. 10 is supplementary, incidental or consequential provisions. Members content then with clause 10. Clause 11 was on appeals. There was no comments on that received, so members content with 11. Yeah. 12 is commencement. Clause 12, 1 and 3 of the bill provide for the commencement orders in accordance with normal practice. These are subject to no assembly procedure. The examiner for statutory rules suggested it may be more appropriate if what is in clause 12.3 about transitional and transitory provisions were worked into clause 10, which is the supplementary, incidental, consequential provisions instead. Orders under clause 10 are subject to negative resolution unless they amend or repeal a provision of primary legislation, in which case they're subject to the draft affirmative procedure. it's a difference in approach. There's no real fundamental issue. Okay, content with clause 12. 13 is the short title, and there's no comments have been received on 13. Vote intent. Schedule 1, which is the transfer of assets, liabilities and staff commission. Members content with Schedule 1.
What page is that at?
Page 7.
It's, oh, sorry, I'm looking at the,
Enough of
Oh, that, yeah.
It's 13.
there wasn't a lot of comments around Schedule 1.
Sorry, Alban, it's page 13 in your table, Pat.
60. Sorry?
13.
13.
Yeah. Thank you very much.
Yeah, I've got that. Thanks.
Okay. Schedule 2. There's the appeals panels, and concerns were raised regarding the manner of appointment, composition of appeals panels, and that only the presiding officer will be legally qualified. The Law Society suggests that the majority should be legal members, with the third member to be drawn from another relevant background. Department outlined that the aims to ensure a multidisciplinary approach with a range of experience on the appeals panel, which will include people who have experience in relevant areas such as social care for family matters. They'll be appointed through a public appointments process. The Department points out the detail of the proposals in relation to appeals panels will be brought to the committee as part of the regulations by way of subordinate legislation. So on the appeals panels, is that the same point?
Yeah,
you had
that
been making
really is the
earlier on?
same point, so it really would be a matter of subordinate legislation in any event. Yeah,
The detail will be in.
okay.
Okay. On oral hearings, appeals were to be considered without any oral hearing unless that is prescribed in regulations. An issue was raised as to whether appellants should always be allowed to appear in person unless they prefer not to do so. When an application for funding was refused, an outline of the reasons will be provided. The Department outlined that the provision of reasons for refusing an application means that in most situations it will be appropriate to deal with an appeal on paper. So on oral hearings, I'm content. Statutory exceptional grant funding. Are there any issues that members had on that aspect? No. There's funding of civil legal services. Any members have any issues with the schedule? No. Then the issues that I touched on earlier raised by the examiner of statutory rules. These were the new articles on legal aid advice and assistance. It makes for provision for rules in respect of the assignment of solicitor and counsel where criminal aid certificate has been granted. The first rules made are subject to draft affirmative procedure, with subsequent rules being subject to negative resolution. And again, the examiner had queried why the powers should be subject to draft affirmative procedure in the first instance, with subsequent rules subject to negative resolution. In his view, the significance of the powers should be subject to draft affirmative procedure on the first and subsequent exercise of the power. The Department asserted in its written response and in oral evidence that it's standard practice for the first set of rules and regulations to be considered by the Assembly, and that minor changes or modifications which take place thereafter should be subject to negative. The examiner of the statutory rules has indicated that he believes that these powers, these changes are substantial and should be by way of affirmative resolution on both instances, and I would tend to agree.
That's a good point, Chair.
So if members are content, we will be going for the affirmative procedure on both instances. New Article 20A of the 2003 Order. This is the same issue.
Yeah. Sure, it's the same issue to do with affirmative, but this particular one deals with the appeals panels. And again, the examiner's view is, given the significance of the provisions, that it should always be draft affirmative rather than affirmative for the first one and then negative resolution after that. And he provided a further note just reiterating because of the significant powers. He believes he is still of that view, having seen the department's views or comments on his initial views. He remains of that view.
So members content to go with the draft affirmative procedure on this one? Yeah? Okay. Schedule 3 was on repeals and there was no comments received, so members content with Schedule 3. And the Attorney General's proposed amendment to the bill. The Minister for Health had indicated in the context of the powers of the Attorney General that he wouldn't have an objection to the Attorney General having the power to access information necessary to allow him to discharge his functions. However, the Minister did question the appropriateness of the bill as the vehicle to make the AG's proposed amendment. In the initial letter dated 18th of April, the Minister outlined a concern that legislative requirement to produce documentation may have an adverse impact on staff coming forward to provide relevant information. And members are obviously familiar with some of those concerns. Members, any view on the AG's amendment?
I just noticed in some of the responses that some of the health trusts were saying this could provide clarity as to their legal position in relation to documentation, which is an interesting point. But I think that the issues here are not clear. I think it requires further consideration by us as a committee, individually and collectively.
Yeah. Okay. On the face of it, I think there's a natural sympathy to it, but there does seem to be substantive points that I think you would want to have some more scrutiny of.
It's tasty.
And we don't have the time really to do that. That's my only issue.
And when's the faster, fair justice bill being introduced?
Be introduced before the summer recess.
I mean, so that maybe
Better.
ask the AG to consider that.
Okay, well, I'm happy enough
Yep.
that we indicate. I think if the committee we can indicate a general sympathy to wanting to pursue this, but we want some more time to scrutinise it. If we can find an alternative vehicle, we'll be sympathetic to doing that. Okay, thank you. Then the formal clause by clause will take place on the 11th of June, so then the draft report can be prepared and agreed at our meeting on the 18th of June. Okay. Item 7, I'll try to get through the rest of the business as quickly as possible. This is around organisations that must be inspected by the Chief Inspector of Criminal Justice Inspection for Northern Ireland. Section 46 of the Justice Act sets out a list of organisations for the Chief Inspector Over time, the list of organisations has become outdated. The Department is therefore proposing to refresh the list by way of a statutory rule, which will be subject to the draft affirmative resolution procedure. The stat rule will make a range of amendments to section 46(1), all of which have been agreed by the relevant Minister and the Chief Inspector, and which will include adding the Central Investigation Service and Veterinary Service Enforcement Branch in the Department of Agriculture and Rural Development to the list. Robin Swan had been pursuing a private member's bill with the purpose of adding the Department of Agriculture's Central Investigation Service to the list. He has indicated that he will discontinue with his bill depending upon the Department's progress with its proposed subordinate legislation. So if members are content with the proposed statutory rule, unless there's more information needed, then we'll indicate that we're content, and it'll come to us then for formal agreement. Item 8. During an oral briefing session by the Department on the 16th of January, Committee discussed Clause 11 of the Human Trafficking Bill, which relates to compensation for victims of human trafficking, and subject to amendments which the Minister has indicated he intends to make, would require the Department to produce statutory guidance on the procedures for victims of human trafficking to apply for compensation. Members raised a number of queries about the application of the statutory compensation scheme and its accessibility to victims of human trafficking, and officials undertook to provide further information on claims under the scheme and on the forthcoming review of compensation legislation. The Department has indicated that it is satisfied that the scheme meets Article 17 of the Directive on Preventing, Combating Trafficking in Human Beings and Protecting its Victims, which requires Member States to ensure that victims have access to existing compensation schemes. The Head of Compensation Services has issued guidance to staff on handling claims for compensation for victims of human trafficking, and measures have also been put in place to record compensation claims in human trafficking cases where this is known. To date, the Compensation Service has dealt with 8 applications for compensation in connection with human trafficking for forced labour and sexual exploitation. 2 cases have concluded with compensation paid to the applicant. 2 cases have been refused because a crime of violence was not committed and there was no evidence of injuries, and the other 4 cases are currently being processed. In June last year, the Minister launched the 5-year Making a Difference strategy, which included a commitment to fundamentally review legislation underpinning criminal damage, criminal injuries compensation schemes by 2016, and that review commenced on September last year. Work to date has focused on criminal damage compensation scheme, with work on criminal injuries aspect of the review due to commence later this year, with a public consultation document ready for 2014. So if members are content, we will note the information that's been provided by the Department. I think there was something mentioned in the Queen's speech today that Westminster's taking forward around compensation on human trafficking victims.
That might be in relation to the Modern Slavery Bill.
Yeah, there was something.
No, there was something was mentioned.
But clearly, there needs to be more work done in this area. I mean, as mentioned there's no compensation for being trafficked per se. You have to be the victim of a violent crime. If there's no violence shown or no injuries, then there'd be no compensation. I don't know if that's a satisfactory situation or not. It may well be that colleagues don't feel that there should be compensation in a situation where somebody hasn't suffered a personal injury, but we have to consider that.
Well, we're keen to find out more information about today's announcement, and obviously there's ongoing work that the Department's now going to do in reviewing these schemes as well, so we can continue to look at it. Item 9, the Department has provided information on Access NI's performance for the 2013-14 financial year and outlined the challenges the organisation faces over the next 12 to 15 months. The key challenges to be faced include operating the system of filtering old and minor convictions, implementing key changes that will be in the Justice Bill, including the introduction of the update service and delivery of a new IT system by March 2015. The Department has also highlighted the need to implement an increase in fees for enhanced checks of around £3 per cheque to ensure Access NI recovers its cost, as it is required to do. Applications for volunteers will remain free of charge. Any fee increase is subject to DFP and Assembly approval by way of amendment to secondary legislation, so members are asked to note that information. Item 10, the Department has provided a 6th monthly update on its savings delivery plans as at 31st of March this year. Its provisional outturn figures for 2013-14 financial year and details of the June monitoring round return. Provisional outturn figures indicate the Department had an unring-fenced resource underspend of just over 10 million, representing nearly 1% of the budget. 8.8 million of the underspend relates to the police service, and if the PSNI underspend is excluded, the remaining underspend is 1.4 million. In capital terms, the Department underspent by 6.4 million, which represents just over 10% of the budget, and the Community Safety College underspend of 8 million carries forward into the 2014-15 year under HM Treasury Security Funding Arrangements. In relation to the savings delivery plans, net savings of 96 million have been delivered against a net 2013-14 target of 103 million. 7 million shortfall has mainly arisen due to the increased costs of the prison service exit scheme, as more officers are now due to leave than originally planned. However, the Department remains on target to deliver total savings of 109 million by 2014-15. The Police Rehabilitation and Retraining Trust, Police Ombudsman for Northern Ireland and the Probation Board have outlined adverse impacts on frontline services arising as a result of the implementation of savings measures. The Department has also indicated it is facing a range of significant pressures during 2014-15, including a current forecast legal aid pressure, net of reform savings of around £35.5 million, 1.7 million funding required to complete the prison service exit scheme as soon as possible in 2014, a current forecast pressure for miscarriages of justice and criminal appeals of nearly £5 million, a potential police pressure in relation to working time directive costs, which could be around £2 million. Given the pressure facing the Department, work was commissioned to examine the impact of delivering additional in-year savings across all departmental bodies with a view to generating funding to meet pressures whilst protecting frontline areas as much as possible. £13 million has been identified. In the June monitoring round, the Department has allocated 23.5 million for legal aid, 2 million for the O'Brien related costs, 4.7 million for miscarriage of justice and criminal appeals, and 1.7 million for the Northern Ireland Prison Service Exit Scheme. This will result in £12 million of the current legal aid forecast pressure being unfunded based on the latest forecast, and the Department will bid to DFP for this unfunded legal aid pressure as part of the June monitoring round. The Minister for Finance and Personnel has indicated that without clear progress in terms of moving the Welfare Reform Bill through the Assembly before June 2014, the June monitoring process will seek 1.5% cuts across all departments in 2014-15 on a pro rata basis. This equates to £11 million for the police, £5.3 million for other areas in the Department of Justice. The Minister has responded, noting the 1.5% cuts should not apply to the Department given its ring-fence status. However, pending final decisions on these cuts, the Department has asked all bodies to make now to deliver these savings on a pro rata basis. So I appreciate I've went through a lot of that information, but it's there for members to note at this stage. Item 11, the Department has provided an update on progress in relation to 7 commitments for which it has responsibility in the programme for government. 4 of the 7.
Chair, sorry, just before we leave the finance delivery plans, I know we've quite a lot on these weeks, but there's quite a bit in that stuff, and there's quite big figures there as well. And I don't know whether it's appropriate to get an oral briefing or not, but there's some issues certainly I would like a bit of feedback on, whether it's in writing or not. I'm happy to maybe submit something to Christine if we don't feel we have time to do an oral briefing.
Well, if we can fit it in, I have no objection to getting a briefing. Where there's a will.
I don't mind either way, Chair.
It's okay. No, I'm happy that we can get a briefing.
Okay.
In terms of the programme for government, 4 of the 7 commitments have been assessed as on track to be delivered. 2 are broadly on track and 1 is not on track to meet targets within the original programme for government period. Target that will not be met relates to the Desert Creek Training College.
Surprise.
So it's there for members to note.
Yes.
Item 12, the Department has provided a copy of the Northern Ireland Human Trafficking and Exploitation Action Plan for 2014-15. It was published on Monday the 2nd of June. The plan has been developed by the Department collaborating with statutory partners in the Organised Crime Task Force, Immigration and Human Trafficking Subgroup and civil society partners through the Human Trafficking Engagement Group, and represents the collective activity of these partners to address human trafficking and slavery, servitude and forced labour in Northern Ireland. So the plan is there for members to note.
Welcome.
And we can ask the Department for a 6th monthly update on the implementation of the plan if members are happy. Yeah. Correspondence, there's 11 items. Let me draw attention to a number of them. Item 1 is correspondence from the Department responding committee's request for information on background to and rationale for the decision to withdraw funding from the RUC George Cross Widows Association. The Department has indicated that in February last year, the DFP Classification Assessment Committee determined the Association's classification as being in the private sector, which effectively changed the Department's relationship with the Association. As a result, the only mechanism available to the Department to provide funding is via the grant application process. Officials have met the Association on a number of occasions to support and advise on developing a suitable application for funding, which the Department will then review and assess within agreed guidelines. So if members are content, we'll send this response to Gordon Dunn, MLA, who raised the issue with the committee. Item 3 is correspondence from the Department inviting committee members to the launch of the Organised Crime Task Force Annual Report and Threat Assessment for 2014. It's on the 24th of June at 8:45 in the morning in the Titanic Building, Belfast. So if members want to go, if you can advise the clerk. Item 8 is correspondence from the Northern Ireland Human Rights Commission to the Minister of Justice in relation to Clause 6 of the Human Trafficking and Exploitation Bill. The Commission has raised concerns regarding provision relating to paying for sexual services of a child between the ages of 13 and 18 within the Sexual Offences Order 2008, as well as other provisions in regard to the sexual exploitation of children of this age group through prostitution and pornography. The Commission's concern is that under the Sexual Offences Order, to be convicted of such offences, the prosecution must first prove that the defendant did not reasonably believe that the child victim was over 18. So if members are content, we'll request a copy of the Minister's response to the Commission. Any other comments on correspondence that I have left out?
Chair, just you did mention the very first item.
Yeah.
Sorry, I can't read it. From the regarding the RUC George Cross Widows Association.
Yeah.
That seems to be a fairly big change to that. I'm just wondering if we could get a briefing from department officials at some stage on it to explain. Maybe they did mention in the correspondence something about grant opportunities, and I'm not sure how that operates or how it will operate, but it might be useful to get a heads up from them on it, and even if it's possible from the association themselves, that would be possible.
It might also be helpful as a cross-cutting issue to
Sorry,
Chair, it might also be helpful as it's a cross-cutting issue to get an explanation of the DFP why they changed the categorisation of the organisation.
Yeah, I'm happy to do all of that.
Yep.
Okay. We agreed with action then. The rest of the correspondence is outlined in the meeting pack. I have no chairman's business. Is there any other business? Okay. We meet next Wednesday at 2 o'clock. And let me just remind members, there's an informal meeting with members of the Oireachtas Joint Committee on Justice, Defence and Equality. That will be at 12:15 next week in room 21. To discuss the role and interaction of the Policing Board, the Committee and the Assembly.
It's the same date.
It's the same date, next Wednesday. Initially in here, and then we'll be having lunch with them to continue the conversations.
Okay.
So if members could attend that, that would be helpful. Thank you.
This is the Northern Ireland Assembly Committee Room 20.